Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to this morning's sitting of the Massachusetts Appeals Court. It is my great pleasure and honor to be sitting this morning with Justice Neyman on my right and Justice Smyth on my left. And my name is Gabrielle Wolohojian. We have a list of 6 cases this morning, each, and I apologize for repeating the ground rules for those of you who've heard them many times, but some of you may be newcomers. Each side receives 15 minutes to argue. If you are dividing your time on your side, please let us know ahead of time so that we can set the clock appropriately. The clock on the podium will show you the amount of time you have remaining. About 1.5 minutes before the end of argument, the yellow light will go on to give you a sense that it's time to think about how to wrap up. And when the red light comes on, your time is up. If you are in the middle of answering a question to us, we'll allow you to go beyond the red light, but ordinarily the red light really means the red light. You may structure your argument in any fashion you would like. However, I will tell you that the panel will have already read your briefs, most, if not all, of the appendices and the other relevant materials, so you don't need to feel that you need to tell us the background of the case, but of course, if you wish to, you may. With that, I am going to call the first case on the list, which is number 2022P 0761, Commonwealth versus Kevin Smyth. And Attorney Nadeau, I believe you're arguing first.
Thank you, Your Honor. Good morning. May it please the court. I am Stephen Nadeau, Assistant District Attorney for the Bristol District, arguing on behalf of the Commonwealth. The case is here this morning on the Commonwealth's appeal from an order allowing a motion to suppress in the Fall River District Court. It was a challenge to a search warrant, and so the standard of review is based on the 4 corners of the application for the warrant. Our position, of course, is obviously that the warrant application did establish probable cause in this case. The investigation described therein began with an admittedly somewhat vague tip from an informant who had reliably provided the Newport Police Department information in the past, leading to seizure of an illegal firearm or illegally possessed firearm. What he told Newport and is then communicated to Fall River is that the defendant was dealing pounds of marijuana. The tipster had seen him in possession of 17 pounds of marijuana and several firearms.
Did it say where?
No.
He saw him?
And so that is...
With either the drugs or the firearms?
No.
Isn't that a problem for the Commonwealth?
At the outset, certainly in relying on that tip alone, yes. And that's sort of the vagueness I mentioned.
So with that question in mind, how do you satisfy basis of knowledge?
I think that deficiency is cured by the corroboration by the police of several key components of the tip. First and foremost, they are able to establish that the defendant does in fact live at the residence indicated, the Russell Street address in Fall River. That's checked through, the registration, utilities, his phone number is all connected to that address. By their own observation, they are able to see that he is apparently living out of the left side of this address, which is a duplex. And they also make 2 other sort of record-based corroborations that I think are key in the case. First, that he does not have a license to cultivate, or obviously he's not a dispensary, he can't sell marijuana, and he does not have a license to own any firearms.
But may I ask you a question?
Yes.
Because I think the Commonwealth was required to establish probable cause that, I guess, either drugs or firearms, I don't know which, but would be located in the residence itself, not just, if he had, if the defendant had drugs, he doesn't have a license to distribute them. Do you see what I'm saying?
Yes.
The difference? It's really the focus on what gets you inside his house.
So I think the investigation in this case not only cured the deficiency as to basis of knowledge, but established the nexus specifically.
Well, the basis to knowledge, I'm not so sure either, because he wouldn't have had, as far as I can tell, there's certainly corroboration of the confidential informant's information that a person by this name lives at this house. But since the confidential informant doesn't disclose or say that he saw drugs at the house or a gun at the house, there's no way you can corroborate something he didn't say, right? So corroboration doesn't really get you very far on that point.
Well, agreed. I mean, he does say, I believe he's dealing with it.
So you get,
Again,
so
there's
you
no
get, you get
indication.
reliability, but you don't get, the corroboration goes to the CI's reliability as opposed to the basis for knowledge on, do you know that the drugs are in the house?
And so I
if
think
so, how?
that nexus is then provided by the trash pull, where there's, the letter of standing, and there's also the three, I think it's 3 1-pound bags that had been heat sealed, cut open, that smelled strongly of unburnt marijuana.
Did it say 1-pound bags? Is the size of the bag delineated in the affidavit?
Well, I believe it's Trooper O'Reilly sort of ratifies.
I thought it said 3 clear plastic heat-sealed bags.
And then I think it's Trooper Burke's recognition from his experience that that packaging is consistent with 1-pound packaging of marijuana.
Is there any marijuana actually found in the bags?
No, and it doesn't indicate there's residue or anything, but as disclosed in the affidavit, it's just the odor. And granted, the odor of marijuana without more is insufficient to establish probable cause, but it's attached to or connected to these bags particularly that the trooper specifically articulates is for amounts in pounds. And then it's specifically articulated from there, that is inconsistent with personal use.
So if there are 4 bags of trash that are taken, and it's a duplex, and we don't know which bags of trash are associated with which half of the duplex, and we also don't have any information that the letter of standing was found in the same trash bag as the plastic bags that smelled of marijuana, how do we connect all those dots?
I think in a couple of ways, Your Honor. First, when they do the utility or phone records check, there's only one phone number connected to that address, and it's only the defendant's name on it. Again, they don't go to establish conclusively that there's no one on the other side, but they only get one phone number, and it is the defendant's phone number. And their observations as well, they only see the defendant and a small child kind of coming and going from the left side of the duplex. And as they describe the trash pull, I think there might be 4 trash bags, and they say they find these 3 cut open heat-sealed bags in 2 of them, and then immediately following they describe the letter, I think from Newport Credit Union or something like that. And I think I read that as it was in one of those bags. Again, doesn't express that specifically, but I think that's a fair inference from how that section is written.
What it says is we observed 2 trash receptacles on the sidewalk, one for trash, one for recycling. We were able to retrieve 4 white trash bags full of rubbish, which I guess, you would say that must have all come from the same trash receptacle, since one was for recycling and one was for trash, from the trash receptacle and brought them to the police department. Inside 2 of the white trash bags, found 3 clear plastic heat-sealed bags, recognized the bags as a common form of marijuana, and then also recovered was a letter of standing from the Bank of Newport addressed to Kevin Smyth of 44 Russell Street. But it doesn't say, do you see what I'm saying?
Yeah,
I don't see
yeah,
any link between they all come from one unit of the duplex or that all 4 bags. You see the disconnect. It's a duplex?
Yeah, it's not, again, I acknowledge it's not explicitly stated. I think there is a fair inference, again, from how it's presented, that it's found with at least one of these heat-sealed bags. And I would note, too, that we are starting from, again, basis of knowledge not established, but from a reliable informant who has a track record of providing, at least in one instance, reliable information. And so the tip, while in itself is insufficient, the corroboration builds on that foundation. And given that the nature of the tip is this guy, Kevin Smyth, is dealing pounds of marijuana, I believe, out of his house, and then they find, what do you know, 1 pound, 3 1-pound bags consistent with the packaging of marijuana in the trash pull right outside his house. And there's a letter of standing found somewhere amongst them, I think.
What do you think
from
is
that
your
foundation.
What does the Commonwealth think is the closest case on the facts where we've determined that an appellate court has determined that there was probable cause to search a residence? Closest on the facts.
I'm thinking more distinctions, unfortunately.
I got
Given that the kind of operative thing here is the odor of marijuana, I'm thinking of Commonwealth versus Long, which is a fairly recent case out of the SJC at 48 Massachusetts 804, and specifically at around page 813. They talk about, the odor of marijuana without more is not sufficient, but here I would suggest it's...
Was that unburnt marijuana or burnt
I think it was
marijuana?
unburnt in that case, although I think the principle of Long applies to both burnt and unburnt.
Was it a probable cause case, or it was a probable
Yeah,
cause,
that
not
was
a reasonable
warrant
suspicion?
case as well. Yeah, probable cause.
I was going to ask Judge Wolohojian's question, but a little bit differently. Is there a case where you have the following? One, and this is in the context of a probable cause analysis for a search warrant. Your evidence is, 1, a CI who says, I saw someone with marijuana, lots of marijuana and a gun, I think, 9 days ago? Or, recently? Number one. Number one. Number 2, the defendant lives at this particular residence and we've seen him there. And number 3, we did a trash pull at that residence consisting of 2 places, and there were 3 bags that smelled like marijuana but didn't have anything in them. Is there any case where you had that little and it satisfied the probable cause test?
Not that I can think of specifically on sort of this constellation of facts, but I would, there's another case, it's an older case, Commonwealth versus Taglieri, at 378 Mass 199 through 200. I think it's a case in the 70s, but it's been cited more recently by this court, where a experienced detective or officer's training and experience, as long as that's described and his inferential process is kind of set out in the affidavit, so that it's not left to the magistrate to connect those dots, but where he specifically describes, I have this training in recognizing common packaging, how these things are organized, put together, and distributed. and that's based on, training experience, that's entitled to some deference. And again, that's sort of, that principle is sort of discussed in that older case. But again, I acknowledge, we start with a vague thing, but I think the corroboration of that tip in several key respects, including not just of marijuana, but also the quantity of marijuana.
So I want to ask you a little bit about the two sentences relating to what the CI recounted. So in the first sentence, it says, according to CI 1, Kevin Smyth of 44 Russell Street sold marijuana by the pound and stored it inside his residence for distribution. So that's in the past tense. We don't know how long ago. It's got the detail about by the pound, and, it doesn't say basis for knowledge, but it says definitively he stored it inside his residence for distribution. But then the second sentence, which is the one that people seem to focus on, is recently, CI1 had observed Kevin in possession of 17 pounds of marijuana and several firearms, and believed he was storing those items in his house. The way that's phrased would seem to me to suggest that he had observed the 17 pounds of marijuana and the firearms somewhere other than the house, because you wouldn't say believed if he had observed it in the house, right? This whole sentence would have been written differently.
Right, and again, just the nature of the review here, I don't know whether that's something that got lost in a game of telephone that changed over time, but regardless, as presented, I agree.
Right, so because it's just not the way you would write it. If he had
Yes.
seen it, you would say he saw him in 17 pounds of marijuana and several firearms at his house, right?
Right,
So that seems to me to weaken the suggestion that any information from the CI suggested that these 17 pounds of marijuana or firearms were stored in the house.
yes, and so I think
Okay. So
that
it
is
all
the,
turns on what was in the trash pull. To
Yes.
get you into the house, right? I mean,
Yes.
I know you have this, right, because, all right, I think I understand.
yes. And again, I think it's critical that the specific recognition is that the bags are for marijuana in pounds. These are not, sandwich baggies that we're talking about that haven't,
Right.
that might still smell like it's marijuana. It's specifically articulated that these are for a substantial weight, inconsistent with personal use, and the pound element directly corroborates. And I think
The CI's tip. Let me see if there are any further questions. No, all right, thank you very much. Attorney Manny?
Good morning, everyone.
Good morning.
John Manny for Kevin Smyth.
Oh, Smyth, sorry. That's all right.
Thank you. Your Honors, as the court zoomed in on, this case is an issue of probable cause, and the biggest issue is the basis of knowledge. First of all, the information that was given from the confidential informant purportedly was given to a Newport, Rhode Island police detective, and then that information was transferred to a state trooper in Massachusetts. So that isn't the typical scenario where the confidential informant gives it right to the investigating officer. We're removed, or we've taken two steps. In my opinion, that would be basically totem pole hearsay, that information. Notwithstanding that,
Almost all information in affidavits is hearsay.
no, I understand that, Judge, but my point, I guess, is that it's twice removed instead of going directly to the investigating officer. And it's important in this case, the information that was given to the troopers that Massachusetts finally relied on that deals with this issue goes directly to the basis of knowledge. That basis of knowledge, as the court pointed out, this person did not say that he saw the defendant, he saw marijuana or guns in his home. The search warrant specifically was for his home. If he had seen it, it certainly would have been put in the affidavit. That's basically the key in this particular case. He recently saw 17 pounds of marijuana and several firearms and believed he was storing those items in the house. That information, in addition, is past 72 hours, which is typically something that is often seen before getting a search warrant.
What do you do with the sentence before the one you're focusing on? So according to CI1, Kevin Smyth of 44 Russell Street sold marijuana by the pound and stored it inside his residence for distribution. Now, that doesn't have basis of knowledge, but it's a pretty declarative statement that marijuana is in the house.
It is, Judge. Notwithstanding that, I think you need there has to be more. In other words, if this CI was in the defendant's house, there certainly would have been a description placed in the affidavit for the search warrant. You know, I was in his kitchen. It's, you know, we had a kitchen table.
Well, they don't always say that. They sometimes just say, and I was in his house and I saw X.
Well, I mean, that's easy to do without being specific. If he's stating generalities, he did indicate, according to CIA, he sold marijuana by the pound and stored it inside his house. I agree with the court. That's past tense.
Well,
Now,
it's past tense, but it's pretty declaratory of both. I mean, there's the quantity, which is pretty precise, and the statement that he stored it in the house is unambiguous, really. Now, it's true we don't know when.
But the next sentence, Judge, where he says, and believes it's stored in the house. I mean, that's the key.
Do you think we need to read that in conjunction with the sentence before?
Well, I think it can be read separately, and the reason I say that is one is past tense, one appears to be more recent, but if he believes it's stored in the house, the police could have done other things to corroborate. They could have watched the house for traffic going in and out of known drug users. They could have tried to do a controlled buy. They didn't do any of that. The only thing they corroborated was that he lived on one side of that duplex. They don't know if anyone lived on the other side. They do a trash pull.
Well, he owns the house, correct?
He does own the house. That's correct, Judge.
Yeah, so it's not just that he lives in one side, he owns the house.
But they didn't even attempt to confirm or deny that someone else lived in the house. And that also goes to the trash pull. The trash pull is, first of all, it's a duplex, so I don't know how many barrels there are as to it, but there was two out
He
there.
said there was one barrel for trash
there's
and
one
one
each.
barrel for recycling. And they
Right.
took the stuff out of the trash barrel.
But we don't know, Judge, if that is for the entire duplex, if anyone else puts trash in that barrel. They didn't observe, you know, if it came from one side or the other, it was in front of it.
I know, but we're not looking at, beyond a reasonable doubt here.
No, I understand.
So you don't have to eliminate all other possible explanations.
Right.
My question for you is about taking the trash. So the officer says that the plastic bags are the kind that store 1 pounds of marijuana each. And they smell of marijuana, so that would seem to confirm the officer's description of what they are, which is, and he says, having 3 pounds of marijuana is not consistent with personal use. When you have that combined with mail in the trash, connecting the defendant to the trash, and it comes from a receptacle outside that house, and that mail is the same address as the address they're looking to search. Why isn't that enough to get the police inside the house?
I don't believe it's enough, Judge, because, number one, the odor of marijuana in and of itself is insufficient. In fact,
But they do have the CI, the information from the CI.
no, understood, Judge.
Yeah.
But the court, in the motion to suppress, asked the question of the Commonwealth as well. Was there any marijuana found, any, a little bit of it or whatever? And the answer was no. The bags in and of themselves, if the smell of marijuana in and of itself is insufficient, just because there's a bag that could have held it, we don't know if it was put in there by the defendant, by somebody else in the house, and I don't even believe that it matters that much, because if the odor of marijuana in and of itself isn't sufficient for probable cause, then an empty bag with no debris whatsoever of marijuana would be even less.
Sure, but we don't take the facts one by one in isolation as though none of the other facts existed. So I don't think it necessarily helps your cause to say the smell of marijuana by itself, because they have the tip from the confidential informant. So it's
Right.
not by itself. So I'm going to ask you the same question I asked the Commonwealth. What is, but the mirror image of it, on the facts, what is the closest case to this case where an appellate court has said that's not probable cause?
I am not aware of a case, Judge, that is this similar to this case.
So this would be the first case where we say this constellation of facts does not constitute probable cause.
Well, I don't know that it would be the first case, Judge, but
Okay, so what's the closest case?
I don't recall a case that's similar to this. There's, a lot of cases that we cited in the memo that deal with, probable cause and searches based on a search warrant, but these particular facts specifically, I know my brother cited a case, but I'm not familiar with that case, Judge.
Let me ask you a hypothetical.
Yes.
I want you to assume the exact same set of facts as we have here, but in the trash pull, instead of finding 3 1-pound heat-sealed bags or 1-pound bags, strike that, let me ask it again. Assume the same set of facts. Instead of finding 3 1-pound bags without any marijuana in them, the police found 30 1-pound bags, half of which had marijuana residue in them. Would that be enough for probable cause in this case?
Well, I think the fact that there was residue there, combined with there was residue in a lot of the bags, that could be probable cause, Judge.
Okay. What about the exact same facts, except 30 1-pound bags, residue in one of them, and in the other 29, all smelled like unburnt marijuana?
I would think there'd be less of a chance of probable cause.
I'm not sure that the existence of the marijuana in the bags is actually the critical point. To me, it seems it's the indicia of trafficking or indicia of intent to distribute. So it would be the number of bags that would be more relevant than the actual marijuana therein. I don't know if you agree with that or not.
I can see that, Judge, yes. So basically, at this point, I don't believe there was sufficient probable cause. I laid out my arguments. I think there's an issue with the basis of knowledge. There may even be an issue with the reliability. The corroboration which could have taken place, i.e. either a controlled buy or observations of people going in and out of the house, high traffic area. I think that this motion to suppress was properly granted. I would ask the court to uphold that decision. And that's all I have to say at this point.
All right, let me see if there are any further questions. No. All right, thank
Thank you
you.
for your
Thank you
time.
both. It's an interesting case, and we've been helped by your argument and your briefs, and the case is submitted.
Thank you.
Second case, Colin said he was here, but he's nowhere to be found.
Okay, so should we call the third case?
Yes.
Okay. Thanks, Ron. And I like your scarf. We're going to take the next case out of order, because I understand one of the lawyers in the second case is not here yet. So we're going to take 2022P 0436, which is Commonwealth versus Philip Carter. Are the counsel here for that case, both sides? All right. And then, assuming that we still don't have counsel for the second case, are counsel for Chatham versus Chatham Sergeants all here, or no? No, okay. So we'll take that when we get to it. All right. So this is 2022P 0436, Commonwealth versus Philip Carter. And Attorney Cox, we're ready whenever you are.
Good morning. May it please the court, Jennifer Cox appearing on behalf of Philip Carter today. Mr. Carter appeals from a conviction of breaking and entering in the nighttime to commit a felony after a bench trial in Lawrence District Court. And on appeal, he challenges the conviction on two grounds. First, regarding the sufficiency of the evidence of his identity as a joint venture to the housebreak. And second, that misstatements of fact in the Commonwealth's closing argument created a substantial risk of miscarriage of justice. So regarding the sufficiency, he alleges that the Commonwealth's evidence failed to prove beyond a reasonable doubt his identity as a perpetrator of the housebreak, resulting in a conviction based on insufficient evidence. At trial, the parties agreed that Peter Carter, his brother, committed the breaking and entering and was the sole person to enter the home. There was security video at around 3:45 in the morning that showed a pickup truck drive up and Peter walked to the car. So all parties also agree that someone other than Peter, a second person, was involved driving the truck. So the Commonwealth's theory of Philip's culpability was that he was the person, the unseen person driving the truck at that time. So here we argue that even when considered in the light most favorable to the Commonwealth, as is required, that the evidence failed to prove beyond a reasonable doubt that he was the driver of that truck. As you are aware from the record, the driver of the truck was not seen at any time. Sergeant Crimmins was on duty in the area shortly before the housebreak and saw the truck. He did not see the driver, indeed how many occupants were in the vehicle at that time. Although there is video of the truck both in the dark and in the daylight, from which you can pretty well establish that it's the same truck. You can't see who the driver is.
Sure, I think we can all agree there's no direct evidence that he drove the truck on that evening, and so we're talking about whether the circumstantial evidence gets over the proof beyond a reasonable doubt bar.
Correct.
So let me tell you what I see, and then we can talk
We'll
about
dive in there.
not what's missing, right? There's, in every single case involving human behavior, there's usually something missing.
Sure.
But let's talk about what there is actually there. So the car didn't drive itself. Someone was driving the truck.
Yeah.
24 hours later, the defendant was driving the truck with his brother, who is undisputably the person
Correct.
who broke into the house. The truck was filled with stolen items, including items stolen from this particular house.
Yes.
And it appears that those stolen items were in plain view. Enough, whether we call it plain view, enough in view that when the police officer asked some basic thing like, did you just come from Dunkin' Donuts, or what's all this stuff, the defendant says, we've been helping a friend all night move his things. So at a minimum, that would seem to me to show he knows there are these things in the car, and also that he's willing to provide a false explanation as to what they are and how they got there. He then takes off when the officer asks him to get out of the car, drives the car away. So those things all seem to me to suggest consciousness of guilt. And then when they get into the house, there's a knapsack there that contains I've always loved this word, the burglary tools.
Oh, the burglarious.
Burglarious tools. The tools that were used to actually break into this particular house. And in that same knapsack was a prescription bottle with the defendant's name on it. Now, with all of that together, why couldn't the fact finder infer that the unknown person driving the truck on the night of the burglary was the defendant?
Well, I would disagree. I understand your point, but I would disagree with several of the way that you have portrayed the facts, and some of that I think are not borne out by the record. So to sort of start at the beginning, and then of course feel free to interrupt me wherever if I get off track. When they're seen in the truck the next day, they're coming from, the police stop the car because there was some sort of incident at the Dunkin' Donuts. They say it's either an impaired operation or a disturbance of some sort. So when the officer pulls them over, he is pulling them over for whatever happened at the Dunkin' Donuts. And my recollection of the testimony was that he says, where are you coming from the Dunkin' Donuts? I don't believe he asks them about the stuff in the trunk, or in the flatbed. I believe he says that he could see there were bags in the truck, but he's not at this point asking them about that. He does ask, maybe it's just in response to, were you just at the Dunkin' Donuts, where I believe the officer says both of them make the comment, we were helping a friend move and we stopped to get coffee. So I don't think he makes any representations that the stuff in the trunk is the stuff from helping a friend move. So I would disagree with that. As far as the items being in plain view in the truck, I also would take issue with that. The items in the back of the truck are all in bags, duffel bags, some sort of containers. So the officer says that the only item he can see are the bottle rockets sticking out of it, and which are not alleged to have been fruits of the breaking and entering. So I think it is entirely reasonable to compare this to cases like Alameda and Garcia cited in the brief, where they're not in plain view. The fact that stuff is there is in plain view, but its nature, what the actual items are not in plain view. And I think that's different here, where the only items seen, the bottle rockets, are not part of the fruit of the breaking and entering. As far as the items in the cab of the truck, which would be where he and his brother are situated at that time, they are in plain view as far as we know.
And they're also stolen somewhere.
Some of them are stolen. Yeah. But you wouldn't know that unless you looked at them. For example, there's jewelry, there was the passport. Unless you open the passport, it's not readily apparent from the outside as a stolen good. So
Am I correct that in addition to what Justice Wolohojian summarized, that on the defendant's person, there were also 12 $100 bills found on his person and a $2 bill?
Two $2
bills, yes.
Is that correct?
Yes.
And the victim testified, if I'm not mistaken, that among other items taken from his home were 9 to 10 $100 bills and some $2 bills?
Two $2 bills.
Two $2 bills, yes. So correct, that 9 to 10, 9 or 10.
So adding that to the calculus, adding that to Justice Wolohojian's summary, how do you get around, under the Lattimore standard, the denial of the required finding of not guilty?
Well, there's an important distinction for the $2 bills, which is an issue in this and in the closing argument issue. The homeowner was very specific that the $2 bills missing were a unique collector's item. It's two $2 bills on a single uncut sheet. And here, the Commonwealth, it's the Commonwealth's burden of proof, and for reasons I don't know, and I'm sure the Commonwealth's attorney on appeal probably does not know the answer to either. I don't know why they didn't take photographs of the evidence. The only photograph is what is in the appendix, which is a photograph of the evidence bag that shows basically the handwritten amounts, one $1 bill, two $2 bills. So there's no description that the $2 bill matches, and while $2 bills are...
It's uncommon for someone to be carrying around two $2 bills in their pocket and exactly, 12 $100 bills in light of the victim's testimony? That's quite a coincidence, don't you think?
It is a coincidence, but I think that where it is distinguishable, where it's not the same amount of $100 bills, which, certainly I'm not going to press the point. It's possible that he,
What would
it doesn't mean it's
preclude-
not possible. Some of them are stolen.
What
I'm
would
sorry.
preclude the inference that it was the $2 bills that were stolen?
Because it doesn't match what was stolen. And
You
where,
don't know, it doesn't, there's no evidence that says it doesn't match.
right, but it's the Commonwealth's burden of proof to show that it is, where they're heavily relying on this.
Given the unusual nature of $2 bills, the proximity in time, the other attending circumstances, including the fact that he's sitting in the car with goods stolen from this house, what would preclude the inference that it was the same $2 bills?
I think that we had available evidence. They also didn't ask the homeowner or the police officers, frankly. The officers say that Mr. McRoy came and identified items as belonging to him. They never asked him, did you also identify the money? And certainly, it's unreasonable to expect the homeowner to know the serial numbers of his $100 bills. So I'm not disputing that part of it. But for the $2 bills, certainly someone could have asked, did you show him, were there two on one sheet, and did he say those are mine? So I think where there is something peculiar or specific about the $2 bills, and it's not that it goes beyond that the evidence could go either way, where they had available to them, and they have the burden of proof, a way to establish these are, that you could have asked either the officer or the homeowner, you could have had a picture of the money, something like that, and they didn't. I think it is speculation to fill in the gap there.
Don't those distinctions and claims of what's not there go to the weight of the evidence as opposed to the sufficiency? I think we have a lot of cases that say that.
Yes, I agree. It goes to the weight. But when you look at the weight of all of the things together, that does go to whether it's speculation or based on proof beyond a reasonable doubt. So here, relying on the cases cited in the brief, we would argue all of the deficiencies combined mean it rests on speculation. So given the time, I'm happy to move on to the second issue if there's no other issues on the first one. So,
I just have one quick question
Sure.
on the second issue.
Yes.
And that's, am I correct that there was no objection to the closing argument?
Correct,
Am I
yes.
correct that this was a bench trial?
correct.
Okay. Can you cite to me any case where a substantial risk of a miscarriage of justice was found by either this court or the SJC in the context of a bench trial closing argument where there was no objection made?
I cite in the brief to the Martelli case for the principle that a judge sitting as a fact finder in a bench trial is not per se immune to the influence caused by an erroneous statement. But in candor to the court, I didn't make a note of whether it was objected to or not. So I don't want to misrepresent that it was or wasn't. I just don't remember if it was substantial risk or otherwise for that one.
So for our purposes here today, the answer is no.
Unless that happens to be a case that was substantial risk. So, but to your point, obviously that is going to be sort of the make or break issue here, is that it is a bench trial, and we're not worried about was the jury influenced by something. And certainly there are cases cited in both of our briefs as to, the presumption that a judge in a bench trial correctly instructs his or himself on the law and correctly applies the principles. So here, the difference here is that the judge does mention specifically in explaining the verdict, if I can find it here, the court mentions the uniqueness of the $2 bills in addition to the number of $100 bills as something she found that the Commonwealth has met their burden of proof by establishing. So here, unlike those cases where we have a presumption that they don't consider it, here we know the court did consider it. And so, our argument really rests on the wording where the judge says, the uniqueness of the $2 bills, which is what the misstatement was, and also in addition to the number of $100 bills, which is the subject of the other misstatement in the Commonwealth's summation. So where here we know that the court did in fact rely on that, and by her notes heavily relied on that. I think that's what distinguishes this case.
Through the miracle of the internet, I just looked up
Yes.
the Martinez case, and
Yes.
the judgment was affirmed in that case.
Okay.
So
Right, yeah.
with that in with that fact in mind, is the answer to my previous question no?
Well, I think I wrote down Martelli in my notes. I know Martinez was indeed a case. I may be conflating the two of them, but Martelli was the case that had sort of the explicative language about, a judge is not immune. But as I said, it is entirely possible that was a substantial risk case. I just neglected to write that in my notes.
What was the misstatement in the prosecutor's closing about the $2 bills? Because I'm looking at it right now, and I don't see necessarily a
Sure.
misstatement.
So the prosecutor's statement regarding the $2 bills was the victim did specifically tell the court that there was something unique about those dollar bills. True. And that's what Officer Nelson said. He couldn't remember exactly what it was, but there was something odd about these $2 bills. And that is just not correct. Officer Nelson did not say that there was anything odd about the $2 bills. The question posed to him was, what in particular did you notice about the $2 bills, if anything? And he replied, I don't have any specific recollection. So that is a stark contrast to saying, oh, there was something weird about them. I think it was, as you said, it's unusual to have $2 bills. So I think that is a misstatement of the facts that the court then relied on. So I see I'm running out of time here, so unless there are any further questions, I'm happy to rely on the brief. Okay, great. Thank you.
I don't see any. Thank you very much for your argument. Attorney Cohen?
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. And if it's all right with the panel, I'll start with speaking to the statements of the prosecutor in the closing statement.
Yep, you may want to speak up
I
or
apologize.
adjust the microphone,
A little
but
bit.
there's never any substitute for projection.
Thank you, Judge. So in speaking to the closing, I'll first start with the prosecutor's statements about the $2 bills. So of course, as Your Honor has pointed out, two $2 bills on somebody at any given time is unique in itself. So I believe that her characterization there was not incorrect. And then second, she spoke to the officer and said that he found that there was something odd with the bills. And the Commonwealth would argue that this was a reasonable inference on the basis that the officer had described some of the bills being folded in a manner that was characteristic of being where drugs may be kept. And I believe that the prosecutor's inference that this was odd was reasonable in the circumstances. I would also say, as to the first statement that she made regarding the amount of bills, to the extent that she said that the number of bills described by the victim and the police officer, of course, that was incorrect. However, she, to the extent that they were consistent, I believe that that was a correct statement. And as far as the judge relying on those statements, first of all, of course, it is a bench trial, and what she said about the money, that it was unique and pointing to the number of bills, I think, again, that is a reasonable inference based on the evidence presented. I would also just say, as to the Martelli case and comparing that to this case, in Martelli, the issue was that there was no closing argument whatsoever.
The judge precluded defense counsel from making a closing argument in that
Yes,
case.
Your Honor. And the note about the importance of closings in a bench trial, and it was a footnote, was in regards to the fact that there was no closing argument whatsoever. So again, I think in this situation and in all situations in a bench trial, the judge could be found to have disregarded something that was incorrect and rely on her own memory of the facts. And just to address the sufficiency argument, Your Honor did summarize all of the evidence that the Commonwealth relies on in.
Well, no, I left out the cash in the pockets.
And then Justice Neyman, you did add to that. So that's roughly 6 separate facts that the Commonwealth would rely on, depending on how you break everything down. So the Commonwealth would argue that in the light most favorable to the Commonwealth, this is sufficient evidence, and would just furthermore point to the fact that once defense put on their case, there was really no breakdown of the Commonwealth's case, and in fact, the evidence that was presented can be viewed to have bolstered the Commonwealth's case in that we have a situation where, again, the defendant and his brother's medication are found together in another car, and they, of course, were not identified, but they may have been together, and it just goes to the continuing enterprise between the pair. If the panel has no questions, I'll rest on the brief. Thank
All right,
you.
thank you both. Thank you both for your able arguments, and the case is submitted. Okay, so I think we're going to be taking case number 2022P0905, Commonwealth versus Robert White. You want to take a break after this one or the next one? Okay. Do you want to take a break after this one or the next one? Okay. So for those of you who are planning ahead, we will take our morning recess not after this case, but after the next case. All right? So, Attorney Weber, ready whenever you are.
Thank you. Philip Weber of Smart Wade. First, my apologies to the court for being a little late this morning. Mr. White's case is here today as there was insufficient evidence to show that he was trafficking in the drugs that were found that day. Now,
You're going to want to speak up.
oh, apologize.
You can adjust the microphone, but
Usually my problem is too loud as opposed to not loud enough. Now, there's no question that there was drug trafficking occurring, or at least there's no question that there was sufficient evidence for a jury to find that drug trafficking in general was taking place. And there was sufficient evidence to show that there was drug trafficking taking place inside of the apartment that was searched. The apartment that belonged to Mr. Michael White, as they were as the cousin of the defendant, Robert White. However, there was insufficient evidence to show that Robert was involved in this trafficking. Now, he did admit at trial that he did have drugs, that he did possess drugs. So again, there's no question in regards to that as well, but drugs for personal use. And indeed, the amount that was actually found on his person was 8 grams, an amount that is certainly consistent with personal use, but not with trafficking. Now,
Plus $393, right?
There was a good deal of cash on him as well. Now, in regards to the cash, that was brought up by the trial judge in regards to the denial of the motion for new trial in regards to cash. Now, there are cases that talk about cash being linked to dealing. However, the cases that refer to cash being linked to dealing talk about it when the individual is unemployed, when there's no explanation for why they would have any cash on them. That is not the situation here. Here, not only was Robert White employed, but he was actually employed in the restaurant industry, an industry that is well known for dealing in cash. So his cash is certainly not an issue in that regard. And now, while
the drugs found on his person were packaged consistent with the way they would be packaged for distribution.
that is correct, Your Honor. In fact, was about to be what I was going to address.
Under the Lattimore standard, why don't we accept that they were packaged for distribution? He's carrying drugs that are packaged for distribution.
Now, it could be found that the drugs were packaged in a way consistent with distribution, but really, I think that doesn't show that he was distributing them. It shows that he has drugs. Now,
It doesn't have to be actual distribution. The charge was possession with intent to distribute.
yes, Your Honor, and the point that I was going to is that, now again, he admits that he possessed these drugs, and they are illegal drugs. So the only way a person can obtain these illegal drugs would be to buy them from a dealer. If you buy drugs from a dealer packages them for distribution. All that really shows is that he bought drugs from a drug dealer.
It's another possible inference. That isn't it up to the jury to decide which of those two inferences to make? Because we have some other information. He lives in this apartment, or at least one can infer that. because his possessions are in one of the bedrooms. He's seen coming out of it. He has a jacket in that apartment that has $2,000 worth of cash in it. His car key is in the safe that's in the cousin's bedroom.
I think there is.
That seems to permit the inference that he has access to the safe in which the drugs are stored. There's drug packaging paraphernalia or implements in the kitchen, which is apparently a common area in the apartment. And there may be other things which Judge Neyman will remember and I can't off the top of my head. So why, when you take all those together, why is the evidence of the intent to distribute missing?
Well, because I think all of the elements that Your Honor just listed, every one of them are problematic in a variety of ways. Now, I think it is indeed the idea that he lives at
But
the...
we take them in the light most favorable to the Commonwealth.
Light most favorable to the Commonwealth, but as Your Honors are aware, even that light has its limitations. Now, again, as I stated before, there certainly is a sufficient amount of evidence to show that there's drug dealing taking place in the apartment itself. I'm certainly not arguing differently in that regard. This apartment clearly, and there's certainly sufficient amount of evidence to show that Michael White, the person who clearly lives in the apartment, is dealing drugs there. Now, the safe itself is located in what I'll refer to as bedroom 1. Bedroom 1 is Michael White's bedroom. That's an uncontested fact.
And the defendant's car key is in the safe.
Which ultimately only shows that
The defendant...
it's not his primary car key, that's the spare key.
Well, I don't know, but it shows that the defendant, it attaches him to that safe, and that he would have access to that safe. At least that's an inference that can be drawn, a fair inference.
I think that is...
Let's assume that I think it's a fair inference.
I would still, I understand what Your Honor is saying. I would still disagree
Then you have the defendant's car key in the same safe. You have the defendant having access to the safe in which the drugs are stored.
Well, I think the access to the safe is much more questionable. Someone having possession of theirs in a safe doesn't mean that they have access to the safe. If I stay in a hotel and I ask to use the hotel's house safe in the lobby, I can give them my possession. They can put my possessions in a safe. That doesn't mean that I have that doesn't mean that I have a key to the safe. That doesn't mean I have a code to the safe. That means that someone else is storing a possession of mine in the safe. So just because a possession of his, a spare key, so it's a spare key, not one that he even needs every single day. This would be a backup key. That doesn't mean that he has access to the safe. It means that he gave a possession of his to his cousin, and his cousin decided to store that in the safe. Even if he had access to the safe for the purposes of his key, that would mean that he had access to the safe for the purpose of the key. There certainly is, I would argue, because I don't believe that there is a sufficient amount to show that he does indeed have access to the safe.
What is the closest case on these facts where an appellate court has said there was insufficient evidence of an intent to distribute drugs that were in a person's pocket?
Well, in a person's pocket, Your Honor?
Or just intent to distribute?
Well, in regards to intent to distribute...
The closest case on the facts.
And I apologize that I certainly imagine that I referred to the sufficient cases in my brief, and I apologize that I don't have one to refer to Your Honor at the top of my head, because I think that is the issue here, is that there wasn't, the things that show intent to distribute, the things that show trafficking weren't actually on his person, and that is a significant issue in this case. That really this case does come down in large part to constructive possession, because if we go with what's actually on his person, we have essentially a very small amount of drugs that is consistent with personal use, and really not much else. The Commonwealth certainly...
You say not much else, and the cash on his person, and his connection to the home, and the spare car key, and so as not to disappoint my good friend Judge Wolohojian, there is also, in the second bedroom, a jacket with $2,000 in it, plus prescription medication with his name on it, pieces of mail with his name on it. So viewed in that totality, isn't there a reasonable inference that he's engaged in the enterprise of possession with intent to distribute those drugs, that there is a drug operation going on, and he's part of it.
I would argue that it's not. It shows that he certainly has a connection to the apartment. I'm not saying he has no connection whatsoever. It's his cousin's apartment. He clearly spends time with his cousin there. He certainly spends time around the apartment. And there certainly could be an inference that he was aware of what was going on. He may have been aware that his cousin was dealing drugs, but as your honors know, that knowledge alone would not be sufficient in that regard. The mail that your honor refers to actually has a different address. It is addressed to him, but not at that address. It's at a different address. So if anything, that mail shows that he lives somewhere differently. The prescription medication, I mean, the idea that he just keeps, the idea that he has some of his possessions that are sometimes at that house doesn't mean that he lives there. It just means that he does spend some time with his cousin. And indeed, some of the possessions that were even found there are questionable if it's even his. At one point, there's referred to as some clothes that were found there that they try to argue must belong to Robert, on the idea that they wouldn't fit Michael, and actually it's questionable whether or not they would fit Michael, as there's inconsistent reports of Michael's size. Michael's describes anywhere between, sometimes he's described 5'5" to 5'6", sometimes he's described as being 5'9" to 5'10", and some of the descriptions of his size actually would show that the two of them would be about the same size, or at least close enough in size that they would be able to both have the same clothes. And even if the clothes didn't belong to Michael, the individual, who is living there, that doesn't just automatically mean that they belong to Robert. This is not an either or. We don't have clothes that have to belong to only two people in the world. It could be also a third person.
Let me interrupt you. The clothes don't stand for the strongest evidence the Commonwealth has. But even the evidence that he doesn't live there doesn't necessarily vote in his favor. Based on the expert's testimony of what a stash house is and how a stash house is used and how sometimes this is why dealers keep stash houses. So the Commonwealth doesn't really need to prove he lives there, correct?
It's not an essential element to show he lives there. The reason I address it is because in denying the motion for new trial, the trial judge did seem to rely fairly heavily on the idea that he lived there. That's why I was addressing it in that regard. Your Honor is correct that it's not an essential element to show that he doesn't live there, but if he doesn't live there, it certainly shows a considerable difference in regards to this case, because if he doesn't live there, well, then he has a significantly less link to the apartment, and therefore less of a link to all the different items and things that are found there. It also shows, amongst other things, because one of the things that the trial court refers to is the idea that he didn't have smoking paraphernalia on him, that he possessed these drugs, but supposedly didn't have something that he could use to use the drugs. And if he doesn't live at the apartment, well, then that makes perfect sense. He keeps his paraphernalia apparatuses at his own home, where he would be using them. So I do find that while it's not an essential element of a conviction, it is certainly a very significant and relevant part of the overall analysis when we are looking at this case. Because ultimately, I think what the evidence really is showing is that there was distribution taking place, that he was hanging out with his cousin. And again, there certainly could be argued that there's enough evidence to show that he was aware of what his cousin was doing. But that's the thing. The evidence really shows that he chose the wrong person to hang out with. He shouldn't have been hanging out with his cousin when his cousin was doing these things. When police made observations, that the observations referring to drug sales, the observations always talk about Michael being the ones who are engaged in the drug sales, Michael being the one interacting with these people who are buying things, and Robert is just there. He's just hanging out, he's nearby. There's never any indication that he's the one handing off packets of drugs, he's the one collecting any kind of cash. He's just with his cousin when these things are taking place.
But just on a further link between him and the operation would be the drugs he had in his pocket did match some of the drugs found in the safe, correct?
I'm not certain, Your Honor. I will obviously, if the record states that, then that's what would be stated in regards to that. But because obviously if it doesn't match up, then that really would, further show. And even if it did match up, at most, I think that would show that he might get his drug. It's certainly possible that he gets his drugs, personal use drugs, from his cousin. If he uses, and he has a cousin who he were to know deals, it's actually the most logical thing from that would be that he would get it from his own cousin. But so either it would be that, or if it doesn't match up, then there's obviously a disconnect here showing that he would be even less associated with it. So kind of either way that cuts shows that there's not that sufficient evidence there to show that he would be involved in the distribution.
I would just say, not based on the testimony, based on my colleague's first question, it was in his pants packaged for resale, which would lead to a strong inference that it went from the safe to his pants packaged for resale, as opposed to buying an amount for personal use, which is, according to the expert, wasn't packaged consistent with someone who was buying for personal usage.
I think that is, again, quite questionable in that regards, because the idea is that it's packaged the way that a drug dealer would package it. He buys drugs from a drug dealer, so of course it's going to be packaged the way that a drug dealer would be packaging it. I mean, the idea that we have to assume that a drug dealer would have the exact amounts packaged. I mean, if someone's buying 8 grams, a drug dealer is not going to automatically have one 8-gram bag ready to go. They might have to hand them 8 1-gram bags or 4 2-gram bags. I mean, this isn't Kmart. This isn't somewhere where they have, every different packaging option ready to go. We're talking about illegal drug sales. So really what that shows is just he has drugs that are from a drug dealer. No one's debating that. No one's stating otherwise. So if it's from a drug dealer, certainly it would be packaged in the way that a drug dealer packages them. Seeing that I only have about 10 seconds left,
I don't see any further questions, so I think we have your argument.
Thank you.
Good morning again. Stephen Nadeau on behalf of the Commonwealth. Obviously, our position here is that the evidence was sufficient to sustain the conviction. I would suggest that the evidence was, in fact, overwhelming in support of that conviction. The evidence justified clearly the inference that this apartment was a stash house based on sparse furnishing, based on drugs and paraphernalia found kind of out in the open in plain view, used at least primarily for packaging cocaine, manufacturing or processing crack cocaine, and packaging that for distribution. The evidence also established that the defendant's contact with this apartment was more than just incidental, cutting against any inference that he may have just been stopping by to pick up these drugs from his cousin, the drug dealer. He had substantial amounts, thousands of dollars of cash there. He had letters, pieces of mail addressed to him. Again, I think the address was in Berkeley, but that further supports the inference that this is a stash house for a specific purpose. And again, there's stuff, it's sparsely furnished, there's stuff all out in the open. It's beyond serious question that he was certainly aware of what was going on.
Let me ask you about the stuff all out in the open. There was testimony, I believe it was from the sergeant with the Mass State Police, that there were items, including what appeared to be drugs, on a table near the kitchen. Is that correct?
I'm sorry?
There was testimony from a witness for the Commonwealth, I believe the sergeant from the Mass State Police, who testified there were some items in plain view when you walked in on a table outside the kitchen or in the kitchen.
Right.
And there was testimony about those items, which included, I believe, a scale, some marijuana, some bags of cocaine, that you could infer from the testimony were seen in plain view, correct?
Yes.
And there were a number of photographs introduced through that witness.
Yes.
And the photographs were not part of the record.
No, those were not included. Again, not part of the
But your
defense.
interpretation of the evidence was that those items were in plain view.
Yes, that was the testimony. And there was testimony that some of the other items were found like in a cabinet in the kitchen, but it sounds like they were pretty much all those things described were at least in the kitchen, much of it in plain view, again, out on the table, and described quite clearly that way. Again, the pictures are not here with us, but that testimony is quite clear. What's also clear is that when the officers are kind of beginning the process of executing the warrant, they see the defendant and his cousin going in, and about maybe an hour or so later coming out. And what is most notable is that is the defendant, not his cousin, who has drugs packaged as if for further resale on his person, so that he is the one going into the stash house and now coming out to then, presumably, drugs from the stash he's going on to distribute. Nothing similar found on Michael White. notably.
But the evidence of the transaction, the person that appeared and Michael went out to meet the person, that wasn't Robert, correct?
I'm sorry? Sorry.
No, I need to speak up. There was evidence of two separate potential transactions. There was one individual who came to the address and not the defendant, but his cousin or his brother, Michael, went out to meet the person, correct?
Correct.
So that's inconsistent with the defendant having 4 bags in his pocket ready for resale, correct?
I don't think so, Your Honor. I think, drug distribution can take a variety of forms. That particular customer was showing up for a transaction, but I think the inference here is that the defendant himself was then going on to deal somewhere else to someone else. I don't think the fact that there are multiple customers showing up to this place that may deal with Michael White cuts against that, because again, I think the evidence here is joint venture, not just one or the other having exclusive control over this particular operation, and the jury, of course, were instructed on joint venture. So the fact that one of the other guy is also dealing drugs, I think bolsters the evidence in this case, given the, again, compelling evidence that the defendant himself is also leaving to go continue the distribution. And again, all of these sort of observations are further substantiated by the testimony of Trooper Mark Burke, who's qualified as a DRE, providing a further substantial basis on which the jury, again, in the face of this overwhelming evidence, be confident in their conclusion that the defendant here was trafficking about 77 grams of cocaine. If there are no other questions from the panel, I would simply rely on the brief.
Yes. Okay. So, so we're going to ask that you cooperate with each other and get to us the photographs that were introduced in evidence. Okay. If it turns out that neither of you has access to copies of them, we don't need the originals. If you have copies of what was admitted and you can agree that those are copies of the exhibits, that's easiest. But if you can't, between the two of you, find them or get them to us, then let us know that too, so that we can, it's a little bit more difficult for us to get them out of the trial court. So
Absolutely.
we'll take that step.
And I can represent to the court, just for my brother's benefit, that my office is right next door to the courthouse. I'm happy to track those down, and if for whatever reason they've
We
gone.
can do that. I appreciate that. It's usually easier for us if we ask the trial court, but if you have copies otherwise, that's great.
Yes.
Okay.
Excellent.
Appreciate it, and with that, the case is submitted. Thank you both for your argument. All right, the next case we're going to hear is 2022P0448, Town of Chatham versus Chatham Sergeants and Patrol Officers Union. After this case, the panel's going to take its morning recess, and I mention that just for those of you who are waiting for the later cases. The recess is not long. It's no more than 15 minutes. Okay, so is it Attorney Kuroyan? Kuroyan. Sorry about that.
Better guess than most, so.
We're ready whenever you're ready.
Good morning. I'm pleased with the court. Attorney David Croyan on behalf of the town of Chatham. The matter today is the town's continued appeal from a Superior Court decision, which in and of itself was an appeal of an arbitrator's decision, award, I should say, to overturn the termination of one of the town's then officers, Andrew Hutton. Then Officer Hutton was with the department for several years, and the unique factor to his termination in this entire evaluation is he had multiple instances of prior misconduct. So much so that the town was going to terminate him, but in October of 2016, they entered in what's called the last chance agreement. It's a common agreement often with officers where, in lieu of termination, He was issued a suspension, and he was advised that essentially given a 5-year probationary period, where if he ever committed any misconduct...
We're well aware of the facts, so let me dive into the key to this as I see it. My understanding is that the sole issue before us is whether or not the arbitrator exceeded his authority, correct?
Correct.
Okay. My further understanding from your brief is that you're arguing that the arbitrator is constrained by, number one, the terms of the last chance agreement, and number two, by the issues as framed by the parties. Is that correct?
Yes.
Okay. So my understanding is that well, let me also ask you this. Was there an objection to the arbitrator to the manner in which the union framed the issues?
This one, yeah, the parties were not able to render an agreement as to what the issue presented to the arbitrator was. The town presented theirs, the union presented theirs, and then the arbitrator kind of created his own hybrid version. I don't know if there was...
We have the submissions, the referrals to arbitration or the arbitration complaints, whatever it was that initially was given to the arbitrator from the parties as to the issue. Do we have that in the record?
I believe the appellant, so the process, the union filed the grievance, it was essentially appealing the termination to the arbitrator. The only substantive papers or materials submitted by the parties would have been their individual briefs, which I do believe are part of the record. I have that.
The briefs to the arbitrator?
I believe they were part of the record. If not, the arguments.
That's what you're telling us is what we're looking for? It's just what's called...
Those would have been the only kind of arguments. There were no formal objections per se to the arbitrators at the hearing, because a hearing was presented, both parties in lieu of any kind of...
Maybe you can point me then in where I'm going to find these things in the record.
Yeah, I don't think I saw the briefs or a
I
transcript.
apologize, Your Honor. I don't know if the briefs were attached, because I believe it was just the award, because, and upon review and appeal of the arbitrator's award, admittedly, the town is somewhat limited, so the factual findings of the arbitrator we can't really overturn or really question.
Well, but the question here is whether the arbitrator, as I understand it, exceeded his authority. And I have found cases that say there are a couple of different ways that we understand what the scope of authority is for an arbitrator. The first is whatever is outlined in the parties' agreement regarding arbitration. So I take it that would be the settlement agreement here and the last chance agreement. And the second way is if there's an agreed upon statement of the scope of arbitration submitted to the arbitrator. But we don't know what was submitted to the arbitrator.
It is cited in the arbitrator's, in his award. He does articulate and quote what the proposed issues were by each party, and then cites his own hybridized version. And I would also just...
I'm going to ask that you supplement the appendix, let's just say within 3 days, with whatever documents you contend the parties submitted to the arbitrator concerning the scope of arbitration.
I can certainly do that.
Counsel, related to that, I see there's no transcript from the hearing attached. And it may be irrelevant again in that if the parties frame the scope for the arbitrator in a certain way, more broadly than you're raising it today on appeal, that may be relevant to its decision.
I will confirm, I do not believe there was a recording of the arbitration. I don't think that the scope was orally argued. I think that it was presented on the papers and then as a matter beforehand, and then the arbitrator created his own kind of what the issue was before him.
I see.
But even if we,
Let me just ask you another question for my edification. Assume you felt that the issues as framed by the union went beyond the arbitrator's power to decide. Is there a mechanism by which you can object or ask the arbitrator not to act on those issues for that very reason? And was that done here?
My understanding is no, Your Honor, and I don't believe any objection was raised because I don't believe that the parties presented what they weren't able to come to an agreement, so they submitted their own, and then the arbitrator simply kind of created a hybridized version as to what the issue was.
Okay, so with that in mind, the union asked the arbitrator, framed the issue as whether the grievant violated the terms of the last chance agreement. Why is the arbitrator's analysis then beyond the scope of his power?
And this is, I think, what kind of, for lack of a better term, kind of tripped up the Superior Court on this matter. And the union's kind of position is, setting aside our argument that we don't believe that was a proper authority, even if we agree that that was the correct issue presented to the arbitrator, he still cannot alter the terms of the collective bargaining agreement between the parties. I want to clarify, too, the term of agreement. There is a last chance agreement, which is kind of unique to this factor, but also important to all grievance decisions before an arbitrator with the union is the collective bargaining agreement between the parties. The grievance procedure specifically states, I believe it's Article 7 within the CBA, that the arbitrator cannot alter, amend, modify, or affect the language within the CBA. The issue, even if the issue before the arbitrator was whether or not Hutton violated the last chance agreement, i.e. particularly by incompetence and breach of, and by not performing his duty, neglect of duty, he didn't just simply say his conduct didn't render that. The issue was that the arbitrator said that even if the facts alleged occurred, which he seemed to indicate he believed, it could not constitute a breach of duty because it was not the officer's duty to render aid to a civilian while on a detail. The issue there is that Article 3 of the CBA, as the management rights, says that it is solely vested within the chief of police or the town selectman to determine the procedures and expectations of officers' duty.
Let me ask you what the consequences of this argument are. Because as I see it, the arbitrator may have done two things. The first is to determine whether the facts constituted a violation of any of the enumerated rules in the last chance agreement, paragraph 1 of the last chance agreement. Are you with me there?
Yes.
Okay. So that, can we all agree that it was within the arbitrator's authority to determine whether the facts violated that paragraph of the last chance agreement?
We would again reiterate that the language of the last chance agreement was more of him, limited his scope to affirm the facts as alleged by the union. But arguendo, if that was, we did concede that was the argument, we would again say that.
I'm just
yes,
asking
I'm with you,
to
yes.
say, you're with me, that like I have a hard time reading paragraph 2 of the last chance agreement or the paragraph pertaining to the arbitrator's authority under the settlement agreement as not allowing the arbitrator to determine whether the facts at issue violated paragraph 1 of the last chance agreement. So assume that we were to conclude that the arbitrator was within his authority in determining that these facts did not violate paragraph 1 of the last chance agreement. Are you with me?
Yes.
I understand you're making a second argument, which is he shouldn't then have gone on to decide whether the facts violated the collective bargaining agreement, or there was or whether the facts otherwise constituted a reason to discharge this officer.
No, Your Honor, if I may clarify. So, given the last, typically the arbitrator is also there to determine whether or not the severity of the misconduct warrants termination. That is not an analysis he must conduct for the last chance agreement.
That's right, but he seems to have done it here.
After he did so.
Right, so that's what I'm trying to find out. Are you, if we were to determine that it was within his authority, the arbitrator's authority, to determine whether paragraph 1 of the last chance agreement had been violated, what then?
Well, so his analysis would be whether or not Officer Hutton violated the last chance agreement by committing misconduct that violates any of the enumerated policies. And he did do that analysis, and he concluded it did not. But In rendering that decision, he didn't say that the conduct didn't occur, or that the conduct didn't violate department procedure. He stated specifically that it could not possibly be found to exceed his duty because it was not the officer's duty to
I
render aid.
understand all that, so it must be that my question is not clear to you. My question is, if we were to conclude that the arbitrator did not exceed his authority when he decided that the conduct did not violate paragraph 1 of the last chance agreement, I take it your argument is that the arbitrator exceeded his authority when he then went on to determine that the conduct was not a dischargeable offense.
No, Your Honor. We don't concede that in and of itself it was not dischargeable. The issue, there's two aspects of one, whether or not the conduct, but in rendering his decision that it did not violate the last chance agreement, he did so by amending and altering what the officer's duties are, which he is not authorized to do. Section 3 of the CBA gives that exclusively to the chief of police, who has given multiple enumerated policies and regulations emphasizing the need for professional conduct, rendering aid to civilians.
What do those have to do with the last chance agreement?
Because one of the subsets was his neglect of duty. The chief of police has specifically stated it is within an officer's duty to act with professionalism and render aid to civilians. And then the arbitrator said, I find that that was not his duty.
So this helps me. It seems to me this is weak territory for you, because pretty much if the arbitrator is acting within his authority to determine whether something violated paragraph 1, the fact that he got that wrong is usually not open to
No, Your Honor, it's not that he simply got it wrong. It's that he is determining, by rendering that it was wrong, he did so solely by altering the department's policy. Let's say a different example of one of the reasons on the last chance agreement was tardiness. And the department and the CBA said that the chief of police may dictate procedures for when officers arrive. And we have a written policy similar to what we have for professionalism that all officers must arrive at 8 a.m. And we alleged, and that Officer Hutton arrived at 8:30. In his decision, the arbitrator would say, well, let's say, I believe that he arrived at 8:30, but I believe officers should be able to arrive at 9 a.m. That is, in essence, what he's done with this, because he said, I don't find that it was his duty. I am altering the duties of not just this officer, but all officers who, while performing a detail.
What you seem to be saying is that under the CBA, only the chief or the department determines what constitutes neglect of duty or what constitutes incompetence ultimately.
Well, what sets forth the standards of expected duty and performance that the arbitrator did not find that his misconduct did not rise to the level of breach of duty, or that there weren't any enumerated duties he didn't violate. If there were policies, for example, that weren't codified, or if he didn't find that the town did not present duties that he didn't breach, he found that there were multiple. We have the department's expectations, we have the handbook, we have the professionalism rules that are all submitted to the arbitrator. He simply found, well, I don't believe that that is within officers' duties. And he is absolutely without authority to dictate an officer's duties.
How could the arbitrator here have come to the conclusion that the officer violated 501 and 502 of the last chance agreement? How could he have come to that conclusion?
Well, that conclusion...
Without offending the CBA.
Right, yeah, he could have found that, that was the argument put forth by the chief in the internal investigation, that his conduct did violate those procedures, so he would have been simply adopting what the chief of police had already...
My question was, how could the arbitrator have determined otherwise? You seem to be saying this is submitted to arbitration, but heads, the town wins, and tails, the union loses.
No, he could have found, just in the interest of time to address the question, that either the factual circumstances alleged didn't occur, or that there was not an enumerated policy or duty that he had violated. He didn't render that. He didn't say that there wasn't a duty or obligation presented.
He said his duty was to direct the traffic, and he was doing that.
Correct, but that's in direct contradiction to what the actual enumerated duties of the officer are, which the CBA says only the chief of police in the town can propagate.
May I ask one more question?
Sure.
I want to go back to my first question,
Yes.
which you've acknowledged that you did not object to the issues as framed, whether it was you or your client, did not object to the issues as framed by the union and did not ask the arbitrator not to address them. My question was, though, is there a mechanism for doing so?
Okay, well, my understanding is no, Your Honor, that we presented the issue, then in order to render the hearing, the arbitrator created.
If you think by definition, if you look at a particular issue that is raised before an arbitrator, and you know that that issue goes beyond the power of the arbitrator, he still gets to decide it?
I would say no, Your Honor.
So what mechanism is there? Can you object? You still haven't told me.
Frankly, Your Honor, I don't believe that there is. I think it's, frankly, I mean,
I'll ask your colleague the same question.
I think in the interest of time, if there's any further questions, I'd be willing to address
Want me to
them.
check? No? No, thank you. We have your argument and we have your briefs.
Thank you, Your Honor. And I will supplement the, I think, I believe the only thing that would be relevant, I'll be free to confer with my brother counselors, the briefs submitted by the unions, and they cite the same exact exhibits, so I think just in the interest for the court's time, that just the written briefs that were submitted by each party, I'll supplement.
We'll try to work together, but what we're looking for is to see what exactly you submitted to the arbitrator relative to the scope of what you were submitting to arbitration. That's what we're looking for.
All right, thank you, Your Honor.
The arbitrator's report makes it sound like there are witnesses and testimony. So there might have been a hearing, there might be a transcript.
I'll confirm that if there was.
Please do.
Good morning, Your Honors. John Becker, representing the Chatham Police Union in this case. I want to address some of the questions that have come up. One of the questions is about a transcript. Very unusual to have a court reporter in an arbitration. They're fairly informal proceedings. It's also very unusual to have written motions with the statement of the issues. Normally, it's done orally. These things are fairly informal. I will represent to you that the statement of the issues, and I don't think my brother will disagree with this, that the statement of the issues that's set out in the arbitrator's decision is verbatim, word for word, what the parties submitted.
Parties submitted jointly?
No, each party submits their version of the issues.
Okay, so, but what I have found are cases that say an arbitrator exceeds his or her authority. When the arbitrator goes beyond what the parties have agreed will be the arbitrator's scope. And this makes sense to me because arbitration is a creature of agreement. So you can get an agreement either in writing, so for example here the last chance agreement or the settlement agreement or some other written agreement, or by an agreed upon statement of the scope of arbitration to the arbitrator. Or perhaps there's some statutory provision for arbitration that sets out the scope. I don't know. But here, there was no agreed upon statement of the scope of arbitration to the arbitrator, correct?
Correct.
Okay, so we're only looking at the agreed upon scope of arbitration in the LCA and the settlement agreement, correct?
Not correct.
Why?
Because the arbitrator recognized that once he's made the decision.
Okay, so I'm going to need a case that says the arbitrator can do that, because I went looking and I couldn't find one where the parties do not agree on the scope of arbitration, where they do not submit an agreed upon statement of the scope of arbitration, that the arbitrator can decide the scope of arbitration. Do you have a case that says that?
I don't have a case, Your Honor.
Okay.
I do know that it happens frequently, but I don't have a case in front of you. I can certainly look and provide supplemental.
An appellate case that says an arbitrator can decide its own scope of arbitration.
I think that in this case, and this is addressing Judge Neyman's question, that the objecting party has an obligation to do something about that.
Do you have a
if they
case
have a
for
Case
problem.
says that.
What's that?
What's the authority for that proposition? What case says that there's an obligation to object?
There are numerous cases on substantive arbitrability, and that's really what this is. If
That wasn't Judge
It's a
Nyman's
question-
question. If you're going to tell us that there was an obligation to object, as opposed to just two competing statements of the scope of
Not an
arbitration.
obligation to object at the hearing. The obligation is to object in the brief, and then in the 150C petition to vacate. That's the opportunity for the town to make this argument. And the
But
town
they
never
did.
made the argument. They never made it. They never made it in their 150C, and they never made it here. They never made it in the briefs to this court. They never made it in the briefs to the Superior Court. That argument is
You're
waived.
misunderstanding the arguments. I thought the whole case was about the scope of arbitration.
They never made a case that the scope of arbitration that they're talking about is his scope, his authority to decide whether something violated the last chance agreement. That's what my brother has been talking about this whole
They're
day.
making two arguments. They're making an argument that, as I understood the brief, that the arbitrator exceeded his scope of authority in deciding whether the conduct violated the LCA. Let's just set that argument to the side. And then they're arguing that the arbitrator exceeded his authority in determining that regardless of the LCA, the officer's conduct was not a dischargeable offense, which was something that you put in your scope of arbitration, right?
I agree with the last statement, but I disagree with the statement before. That was not their argument on management rights. Their management rights argument is the chief has certain management rights to determine the standards of conduct. He determined those standards of conduct, that neglect of duty is improper, and that incompetence is improper. We're still talking about the LCA here. There's nothing in this isn't the issue of what happens when you get beyond the LCA. This is the issue of that the town is saying that management rights are being abridged by this arbitrator determining that Officer Hutton's behavior was not neglect of duty, was not incompetence. Okay, it's the same argument. It's clothed in different clothing, but it's basically saying, and our response of it, as we say in our briefs, is of course the chief has the management right to determine that neglect of duty is necessary. You can't neglect your duty and you can't be incompetent. But when it comes to an arbitration and the broad definition of grievance in the collective bargaining agreement, which the arbitrator recognized, gives him the power to look at, to say whether this person's behavior, in this case, and what the arbitrator called a minor act of discourtesy, whether that constituted incompetence or neglect of duty. And it didn't. And he found that it didn't, and that decision is not reviewable by the court under the extensive case law indicating judicial deference to arbitration awards. There is no evidence in the record anywhere that I have been able to find that the town ever objected to the idea that the arbitrator couldn't go on after the last chance agreement question was decided to determine whether there was just cause for, what else was the arbitrator supposed to do at that point? If he said
the only thing that the parties had agreed would be arbitrated in the last chance agreement. What I'm struggling with is everything after page 21 in the arbitrator's decision, essentially, or 22, where he gets to the end of his LCA analysis. And then he says, I'm going to keep going. That, as far as I can tell, was never an agreed upon piece of the arbitration. There was if the arbitration was submitted under the LCA, which it looks like it was, How do you get there?
The arbitration was submitted on the termination, Your Honor. It was not submitted on the LCA. The LCA was one of the issues, obviously, and a very important issue in determining whether the termination was appropriate. But we had to decide, does this person go back to work or not? And just answering the question, did he violate the LCA, if the answer is no, you still have to know, is he going to go back to work? Is he going to stay out? How else would that be decided? And the arbitrator recognized that it was implicit.
But don't you need to get there under an agreed statement of the scope of arbitration if you want that arbitrated too?
The union, the town never objected in their brief at any level, either to the arbitrator.
Is there a case that says they need to? Because I have found cases that say the parties need to agree.
I don't have a case that says they need to. What I do have is many cases saying.
I'm sorry, and you submitted competing statements of the scope of arbitration. Why isn't that the equivalent of an objection? You objected to theirs, they objected to yours, you had competing ones. No one agreed. It seems to me
They left it in the hands of the arbitrator to make that decision. I don't have a transcript. That's what normally happens. I can't say this, it's not in the record, but what normally happens is when they don't agree, the arbitrator says, okay, do you agree that I will make the decision about what the issues are since you guys can't agree?
Okay, but we don't
and
know
the parties
that
normally say
either.
that. We don't have that in the record, I agree.
Yeah, we don't know.
It almost sounds like you're arguing waiver.
Yes, I am arguing waiver. There is no, it would have been very simple to make this argument either before the arbitrator, before the Superior Court, before this court. They didn't make it. The argument would have been, once the arbitrator decided the last chance agreement decision, he had no right to go on to the just cause question. They never said that.
So I'm going to ask the same question, which is, assuming that what you're arguing is tantamount to waiver, is there a case that supports the proposition that if you fail to object or raise the issue of disagreement of issues, et cetera, before the arbitrator, that it's waived?
I don't know of a case, but I know that there are many cases that say that an argument is waived if it's not raised below. That's a standard appellate. I don't have a case, but I know there's many cases that say that. You know, they had 3 opportunities to bring up that issue, and they never did.
Well, I'm looking at again, we're hampered because nobody put what we needed into the record. So,
Your Honor,
so I'm looking at the last page of the judge's decision on the motion, the cross motions on whether or not to affirm the arbitrator's award. And in discussing the topic of whether the arbitrator should have gone on to consider whether the officer's conduct constituted, quote, just cause for termination under the CBA, so it appears to me the argument was made to the Superior Court judge, or else why would the Superior Court judge have reached that issue? The judge says the town specifically asked the arbitrator to decide whether the behavior constituted just cause for termination under the CBA, regardless of whether his behavior violated the LCA. Now that seems to me clearly erroneous, because I didn't see that in the statement of what was submitted to the arbitrator. That looks to me like what the union asked be arbitrated.
Your Honor, I'm looking to see if there's anything in the Superior Court brief that raises that issue, and I don't recall off the top of my head the town Superior Court brief. I'm assuming that's where the judge got it from, but I don't know off the top of my head. the town's focus all the way through was on, and I don't see it, Your Honor. I'm not saying it's not there, but just in a brief review, I don't see that argument.
Am I correct, there was no oral argument before the Superior Court?
No, we had oral argument, yes.
Okay. And we don't have a transcript of that, do we?
No, we didn't get the transcript. There was nothing.
Because in reference to Justice Wolohojian's last question, if the town had made that representation at the hearing, it would be, or didn't, whether they did or did not, it would be nice to know.
Yeah, the judge, it's certainly plausible and believable that that statement, that the town specifically asked the arbitrator to decide that Officer Hutton's behavior constituted just cause, was not made by the town. I can't find any evidence that it was made by the town. And it would be inconsistent with their position, which was they were completely and totally focused on the last chance agreement issue because they thought you couldn't get past that issue. But the arbitrator recognized that he had to have some plan B if the last chance agreement wasn't violated. He still had a discharged officer in front of him that he had to do something about. And nobody ever objected to him moving to that next step.
Why couldn't he just say, you discharged him incorrectly under the LCA, period? He went to a whole different step and he said, you know, I'm also going to decide whether or not this violated his duties otherwise, or whether his termination, he looked at a letter written by the chief that had a number of other reasons for the discharge, decided to review all of those and said, well, no, I don't think that was enough either under the, what, collective bargaining agreement?
Correct,
Yeah.
under the collective bargaining agreement.
I mean, all right, I think I'm going to, let me see if there are any further questions. Yes.
How would you assess the union's first question, number one, as compared to the issue as framed by the town? Do you think there's...
Actually, I think they're essentially identical in terms of the analysis that you would do. The only difference, I would say, is that the town's question is more specific in terms of focusing on whether they violated the specific rules. So they mentioned the rules by name. And I think that's what the arbitrator did. The arbitrator looked, as Justice Wolohojian pointed out, the arbitrator looked at neglect of duty, incompetence, and assessed whether these behaviors fit those and determined that they didn't. And that was well within his authority. There was nothing, my brother is completely incorrect when he states that there was something in the neglect of duty rule that specifically said, you know, when you say these things to a citizen, you are automatically considered incompetent or neglect of duty. It doesn't say anything like that.
Were the concerns about the scope of the arbitrator's authority that have been expressed today by your brother, were they raised below?
No, they were not. The issue the town has been raising all along is basically the chief gets to say what's neglect of duty and what's incompetence, and the arbitrator can't say differently. And that's just not the law.
All right, I think
Thank
we
you, Your Honor.
understand your arguments.
I'll work with my brother to get what we can to you.
That would be great. And the case is submitted. Panel's going to take its morning recess, which is about 15 minutes. So for those of you who are waiting for the last two cases, we'll be back in 15 minutes.
Order, all rise, please. Order not recess.
right, the next case is partially impounded. So I just want to caution everyone that we don't use names in that circumstance. So we'd appreciate it if you refer to people such as husband, wife, child, that kind of thing. We try to remember that too. That said, so when I call the case, I'm going to call it by initials. The case is case number 2022P0856, KT versus BT. And Attorney Durland, we're ready whenever you are.
Good morning. May it please the panel. My name is Sandy Durland of Warner, Federico, and Ryan. I'm on behalf of the appellant, whom I'll refer to as the husband. This appeal involves a Rule 12 dismissal of a complaint for modification. It's a very narrow issue. It's one that I expanded on quite extensively in my blue brief, perhaps to a fault. I did include argument to provide context to the panel. But that said, and unless the panel has any questions, I'll just make some remarks to reinforce my argument.
Well, I'll start you off.
Okay.
Why have a formula that has no ceiling if it's meant to have some limitation?
Your Honor, I didn't quite hear.
Sure, maybe I can speak up. Why have a formula that has no ceiling if there is meant to be some limitation?
Well, that's a fair question, and I think the lack of a ceiling is what's driven this case to its procedural posture at this time. And there was also a floor in this case to provide some base amount of support for the wife, but all of which merged. And the mere fact that a formula is included, and the mere fact that trial judges in this court has cautioned about trying to adhere as much as possible to the expressed desires of the parties under Burke-Hume and under Huddleston, it still provides the right. The merged provision still provides the right to come to court and to seek a modification. It doesn't mean you're going to succeed on the modification, but it gives you the right to bring the claim.
If you have a material change in circumstance.
And here...
So it seems to me, but maybe I'm wrong, that we're probably talking about material, the word material. So let's say, I think the top tier on the sliding scale was $1 million, right? So let's say his income was $1,050,000. Would your complaint have been properly dismissed for failing to state a material change in circumstance?
Well, I would say it would not have been properly dismissed, given the four allegations in the original complaint. And if you change the one which involved a tenfold increase in income, or more than a tenfold increase in income, and limited it just $1 million, which is the formula's cap, I would still say that the husband is still entitled to seek a modification, because his modification was not solely based on the formula. There were other components in his complaint which the trial judge looked past.
Let's just
starting first with need.
Let's look at the alimony piece alone, okay? So, and then take my hypothetical in that light. To the extent that he's looking for a modification of the alimony formula, if his income is $1,050,000, that's what he's got, would he survive a motion to dismiss?
I think he should, yes.
How?
Well, if you're let me circle back. If it's just that claim, if it's
Alimony,
just the
just the
income
alimony,
and
that's-
nothing else, I think it would be a harder argument.
Okay, so let's take that
Because
as
the language envisions that.
Exactly.
Yes.
All right, so it seems to me that to the extent that you've got any argument on the alimony piece of your modification complaint, it has to be that the order of magnitude of the difference in the income is such that you were entitled to have at least a hearing on whether modification was in order. What is your best case for that on the upward side? In other words, where there's an increase in income. You know, we're talking, it's very common for us to see modification complaints based on a decrease in income. But what's your best case where there's been an increase in income?
At the Rule 12 stage?
Yes.
I will confess, I don't know if I have a case in that context. Many of the cases that I certainly discussed at length go past the Rule 12 dismissal stage. But I think the best, you know, insofar as the complaint itself is concerned, I think, you know, one that comes to mind is the Pagar case, of which I cited. I think it's 9 Mass App Court 1, I believe. I'm not going to admit that I can tell you the facts in that case, but that case talks about a modification being apt when the financial resources and needs of the parties change. And that's exactly what's happened here. And that's why it was wrong for this judge, who was skeptical, to be sure, and his comments reflect that, to effectively conclude at the Rule 12 stage that this was not going to succeed. And that's not the standard, I dare say, for that procedural posture.
I'm going to ask you about the request to modify the child support payment. As I understand it, there's not yet any child support obligation.
Right.
So why is that request not premature?
It very well could be, Your Honor.
Okay, so that, would we agree that that was properly dismissed? I mean, we're not going to modify something you don't pay, it's not, your client's not
Right,
paying
it would
you
probably,
anything.
I apologize. It would probably be premature to address that issue when it could never come to fruition. I agree. I think it was probably a pragmatic approach by trial counsel to sort of wrap it all up in one bundle.
Okay, and where the parties, so I see the structure of this particular settlement agreement in the following way, but you'll correct me, which is that the alimony was, in essence, I don't want to call it purely a substitute, but child support was, the fact that all the payments were designated as alimony as opposed to child support, and child support doesn't kick in unless alimony terminates for some reason before the kids are emancipated. Was there a tax benefit to your client from structuring these payments that way? Is that why this was done this way?
Well, the bottom line is,
He gets to deduct alimony payments.
right.
Does he get to deduct child support?
Well, alimony, the deductions for alimony, I think, ended in 2020 when the code was changed. This was a 2019 decision, and the percentages, you know, which were descending, started at the 32.5%, which is consistent with both practice, and it's also consistent with the Reform Act, the Alimony Reform Act, which envisions a 30 to 35% and or need-based alimony order.
Okay, so why, in your view, would a settlement have the parties have, do we have any insight in this record as to why the parties structured the payments in this way? So that structured them as alimony as opposed to child support? Or
Well,
some combination of alimony and child support?
I don't believe there is anything in the record before the court now. I was not involved at the divorce stage. That was an agreed-upon provision. My best guess, I think counsel might be able to answer that question, is that it would have been a perfunctory, uncontested divorce hearing, and it would simply have been the standard colloquy without too much granular detail. Okay, so I think, you know, back to the point, the judge here did not, with the marginal comments are relatively thin. He certainly made clear what his position was, because in some respects it tracked what the wife's position was in her motion. And I think that no consideration, I think, was given at all to the allegation in the complaint that the needs should have been focused on, or the needs changed, or that there was no longer a need for that level of support. And the focus was then just on the self-modifying provision, Justice Neyman started with, and a waiver of some inheritances. Both of those two components are effectively uncontested. My client filed a financial statement. It reflected his dramatic increase in income. The wife did not file a financial statement, but nevertheless, there was an acknowledgement at the hearing that she had received a seven-figure inheritance. So those facts alone, I think, would have been sufficient, at least for a consideration beyond the Rule 12 stage. But again, one of the big components was the need, and whether there was a need for this amount of support, and whether it was effectively, I used the word, I think at some point, an unjust enrichment. It's probably that and or a post-divorce transfer of wealth, which are both not envisioned at all under an alimony payment.
I think your argument would be more powerful if it just said that there was no ceiling, or if it just said that this agreement is self-modifying. But the agreement actually says this agreement is intended to be self-modifying, and here's the key language, so as to avoid the necessity of ongoing litigation.
Sure. That's, I think, always the case. That's always the case for a self-modifying agreement. But that doesn't, in this case, prevent the opportunity.
I'm not sure I've seen that language in there very often. Perhaps I'm mistaken, but regardless of whether I've seen it, to avoid the necessity of ongoing litigation, and yet here we are. It seems that I'm having difficult reconciling that with the notion that this is a material change as opposed to a change that everyone saw could have been coming.
Well, there's certainly nothing in the record to envision a 1,000% increase in support, irrespective of the lack of a ceiling. And you know, that is a hurdle that the husband would have to get over in the substantive hearing beyond a Rule 12. In my opinion, that would be a hurdle that he would have to address. But it all has to be looked at, I think, as an amalgam of the allegations. I don't think you can take, and I think that's one of the mistakes the trial judge made here, is he focused on two different things raised by the wife, the self-modifying provision and the waiver of an inheritance, as the sole basis for dismissal, when there were other aspects set forth in the complaint that would, I think, be sufficient.
Just excise everything else, and let's look at the receipt of an inheritance. How would that constitute a material change in circumstance, given the structure and the terms of the settlement agreement?
Well, the issue turns on the waiver, the waiver language. An inheritance can always...
It also turns on the formula for calculating alimony, which is not needs-based.
Well...
Or at all pegged to, there was a carve-out, right? The formula takes into account if the wife receives income, because her income gets subtracted from his gross income.
Correct.
It says nothing about you get a gift or you get an inheritance. That doesn't seem to play any role whatsoever.
Well, an inheritance,
alimony calculation.
An inheritance doesn't necessarily always entail income, which then would be plugged into that formula. It certainly goes to one's overall financial circumstances.
But that may not be relevant to this alimony calculation as the parties structured it.
Well, I think it would be in a general sense, because it's a merged provision. And if one's circumstances change for whatever reason, that can be part of the calculus that could drive a modification. Because I don't think, the point is this, I don't think you can excise various components of that
Okay, so you're
complaint.
not relying on the inheritance as itself a material change in circumstance?
It has to be read in concert with the language in the agreement, which provides for merger, and the four components of the four corners of that complaint, all of which are sufficient. Whether or not they succeed, they raise a plausible, a colorable claim. Not necessarily one that will absolutely succeed, but it's sufficient to get past Rule 12. 2-1, and my time is up, unless the panel has any other
I
questions.
did just have one. By the terms of the agreement, the separation agreement, looking at the effective agreement, paragraph 9, it does give the parties the right specifically to that the terms may be modified by appropriate legal proceeding. But then it cabins or it stipulates the basis for such legal proceedings. It cites, protect each party against any attempt by the other party to vary the terms of this agreement after the entry of final judgment. And second, to enable the husband and wife to procure an enforcement of the terms of this agreement incorporated into the judgment. It doesn't mention material change of circumstances.
Well, I think the language in the agreement which provides that the alimony and child support, or specifically in this case, the alimony, merge, as a matter of law, provide for a modification on a material and substantial change in circumstances. In that same paragraph, Your Honor, there is also a second sentence which isn't always included. The first sentence is a somewhat standard merger language. The second one says it's the parties' express intent, or the parties expressly intend to allow for a modification of these provisions. And that's exactly what leads us to where we are today. I'll rest on my brief. Thank you.
Thank you. Attorney Soon?
Good morning. May it please the court, I'm Rachel Sohn. I'm here with my partner, David Cherney, on behalf of the wife, appellee, and I will refer to her as the wife this morning.
Would you please speak up?
I'd be happy to. The earlier comments you had are directly related to the beginning of my argument, which is to say that MGL 208, Chapter 49E, requires both a substantial and a material change in circumstance to occur in the event that an alimony provision is to be modified. Those are the requirements. Not one, not the other, both. In this case, we have an agreement wherein two parties not only contemplated and planned for an increase in income, but they made provisions for that within an agreement. Husband now comes to the court or came to the court on a complaint for modification because he didn't like the deal he struck. Now, what's important, and it is within the record, it's also noted within Attorney Derlin's brief, is at the time the parties were divorced, husband was working for a company named SyncSort. It was privately held. His compensation structure was almost identical to his compensation structure at the time he filed the complaint for modification, which is a base salary, a bonus, and then equity awards. But because that company, SyncSort, was privately held, a liquidity event would need to occur before he was to actually realize an awful lot of money from those equity grants.
Can we look at any of this in the context of a motion to dismiss?
What's interesting here is that counsel has argued that the amount of money is 1,000 times fold what it is that they were experiencing at the time of the divorce. But that equity provision was includable within the amount of earned income to be calculable for support purposes. So to the extent that there was a liquidity event, we all know that it could have been small or it could have been quite large, 1,000, 1 million times.
I'm sorry.
Sure.
My question, no doubt, was unclear. We're here on an appeal from a motion to dismiss. Maybe, but I don't think so. The rules pertaining to motions to dismiss are different in the probate and family court. But normally, they're that you take the allegations of the complaint as true and see if it failed to state a claim. Nothing that you're telling me in any of this part of the argument is contained in the complaint. So I think we really need to look at this in the standard of review that we will be applying, which is what I think I just stated. And so what I look at is the complaint. And what you seem to be arguing to me, and this is what troubles me here, for all I know, you're 100% correct, that it was all within the contemplation of the parties. But if that's the argument, that seems to me that that needed to be determined in some kind of fact-finding proceeding. It doesn't help you on a motion to dismiss. So I'm going to assume that probably you don't want to make an argument, that it all turns on knowing what the form of his compensation was at this company at the time, but on something that could just be determined from the four corners of the complaint.
The four corners of the complaint, a complaint for modification in the probate and family court is a form. You have to not only state what material and substantial changes in circumstances have occurred, but also those terms of the judgment, which equity requires, be amended or modified in some way because of, there must be a nexus between those terms of this particular judgment and the changes that are material and substantial to do something else.
So I'm looking at the complaint for modification, and it seems to satisfy those parameters.
The complaint for modification here outlines the self-modifying formula, the various components.
In detail, yep.
In detail. It shows that there is no cap. There is no cap. The substantial and material changes in circumstances alleged are that wife has received an inheritance, husband is earning far more and wife is therefore being unjustly enriched, and the amount of support being paid to wife no longer supports her need.
So I understand there's no cap on the formula, but if the amount of income is an amount that is far outside, let's just accept for the purpose of argument, far outside anything anyone contemplated. Somehow his income is $6 billion that year. I thought the test for this was whether it was within an anticipated eventuality that the parties had in mind. And how do you get there on a motion, on just a motion to dismiss? Don't you need something to know whether it's outside what was intended?
There is no cap. There is a floor, however.
Right, so you're saying no cap, that means even if he earned $6 billion, the judge can't look at that. It's merged, but the judge can't look at it.
There is no cap.
I understand, but my question is the same as the opposite to
I understand.
Your opposing counsels, which is, it seems to me his argument turns on the magnitude of the change in income, and that your argument may fail depending on the order of magnitude and the change of income. Because if it goes to, as I said, $6 billion.
It, of course, didn't, right? That's not what we're talking about. But
I know.
I do understand your question. And I think we don't necessarily take the face of the complaint on its own. We also take the law that goes into it. We have the Iannacino case, which requires that the facts pled must plausibly lead to relief. And then we have the Berkume case, where it says specifically, where an agreement does not survive, and this one didn't, it is nevertheless appropriate for a judge to take heed of the parties' own attempts to negotiate mutually acceptable terms to them. A judge who modifies the term does not write on a tabula rasa. And that is the issue here. There is a floor. And certainly, the provision merged. If husbands began to earn less, or suffered some reduction in income, he had the ability to file a complaint for modification seeking relief from the order. But
No, there's in my mind, a logical problem or fallacy in your argument about the fact that there's no cap is the end of it, which is that a merged provision, I don't believe that the parties can constrain the authority of the courts. So once you've agreed that the alimony provisions are going to merge, and therefore, you know, they're modifiable by the court, I don't know that you can just say, well, if there's no cap, then the merger means nothing.
And that's not what I'm saying. Actually, my argument is quite specific. Not that there's no cap and therefore he can't seek relief, but instead that a change of circumstances not just be substantial, which would be a $6 billion a year income, but that it be material to the terms of the judgment, the terms of the agreement that he is seeking to modify. Now, what's interesting here, the parties have 4 children, no doubt, and you talked a little bit about the question of unallocated support, what we know of as unallocated support, which would be an alimony award that also provides for the 4 children, for still unemancipated children. And in this case, the parties, it used to be, pre-COVID, that you could go to the Middlesex Probate and Family Court, you could walk in the morning, and if you were one of the first 5 walk-ins in the morning, you could get a 1A divorce as a walk-in that day. It's no longer the case, but it was then. And on December 21st of 2018, the parties walked into the Probate and Family Court seeking a walk-in 1A divorce for the purpose of grandfathering this particular agreement into the tax laws, which allowed for the deductibility of alimony. Because this agreement was reached and put through into a judgment which was found to be fair and reasonable on December 21st, 2018, husband has been able to continually deduct those amounts paid to wife as alimony. That, of course, would not be true if it was child support, which is why it was not structured as both, or one versus the other. It was an unallocated award that in the event that alimony would no longer be able to be paid because of death, remarriage, possible cohabitation, then would revert to a child support award.
What would constitute a substantial and material change in circumstances here?
So that's really interesting, and I candidly, I think it's a question for you all. I think it's a question for us. I think that certainly his income rising to a $6 billion mark, that's substantial, certainly.
What if the husband won the lottery, won $1 billion in the lottery, paid out at $50 million per year, minus taxes, let's say for 20 years, $37 million per year, and that goes down as income? Would that constitute a substantial material change in circumstances that was not reasonably anticipated by the parties?
So interestingly, yes. And the reason being is because there is a comprehensive definition of earned income in this particular agreement.
Assume it's earned income. Assume that whatever the source of it is, it's earned. It would be constitute earned income.
Okay. That particular question was as to lottery earnings.
No, but just, I know, just assume it's, what I think Justice Neyman's trying to get at.
I understand.
The magnitude.
And so the question of, is there a nexus between substantial and material? Although both are required, can something be so substantial as to be material? The answer is probably.
Well, the point of my question is, yes, whether or not it's substantial material, but it's also whether or not under the standard it is unexpected or not reasonably anticipated. So that's what I'm driving at, and now you can answer the question.
Sure. If it's lottery earnings, then certainly unexpected and not reasonably anticipated. In this case, earned income and growth. And in fact, the trial court judge noted very particularly, Attorney Derlin raised it in his brief, he said, is it really that unheard of to have a CFO go on to earn lots and lots more money?
Right. How does that get determined on a motion to dismiss?
And it doesn't, except that, again, there's no cap. There's no cap here. And so we're not dealing with lottery earnings. We're not dealing with someone who changed careers, which would have to be set forth within that substantial and material change of circumstance provision under paragraph 4. Instead, we have someone who's working the same exact job. Same job as he always was. He just makes more money now. And in fact,
Doesn't that require some fact-finding to determine?
No, I don't think so. Not in this case. Here we're looking at the pleading stage. We're looking at this complaint. So if the facts were that we have this judgment with no cap, and he was a teacher when they got divorced, but now he's changed jobs. He worked really hard. He put himself through school, and he's obtained a job as a CFO at a publicly traded company. That change would be material, because it wouldn't just be substantial, the substantial increase of income, but it would be a material change of circumstances. Things are different now. How could we possibly have contemplated that a teacher would become a CFO of a publicly traded company? That wasn't the case.
You're saying materiality requires something other than just the amount at issue?
I am. And particularly in this case, as Your Honor aptly noted, on the four corners of this complaint, have they alleged sufficient changes to meet that material and substantial change of circumstance? And it may be that their argument is, they don't say how much money he's making now, just that it's substantially increased. Okay, maybe you meet the substantial.
No, they say it's significantly greater than the amount he earned at any time during the party's marriage, which I think, read under a Rule 12 standard, is essentially an allegation that it's therefore more than was contemplated as being an expected amount of salary under the cap.
That's not what they say. And that's not actually, that wasn't what was pled, but I think a response would have been different if that was what was pled, because that cannot be alleged, because the agreement in and of itself contemplates income over $1 million. And so to allege a fact like this wasn't contemplated, this level of income, would be an opposite to the facts and circumstances within the agreement that they have to cite in the same complaint as requiring modification. So I do not think that it could survive in that event either. I think that this issue of materiality is really important. It's not just that it be substantial, because sure, they're saying that he's making a lot more money, but that it be material to that particular provision that they're seeking modification of.
So you're saying that the cases that say that it need to be anticipated or reasonably anticipated, those we just ignore?
No, I think that those...
So how do we then not look at the amount to determine whether it's material to the cap?
The amount material to the cap, that's an interesting question. And so I would say that that question actually leans more towards the substantial end of the two-prong test rather than the materiality test. But in terms of why would we not look to the amount? In this particular case, so what's really interesting is in most separation agreements that provide for a sliding scale, if there's a floor, there's a cap, you negotiate both. In this case, there is not. And that is of particular note. It was a particular note to the judge. He found that in his reason for dismissing it. And it's of a particular note as to the substantial and material end and requirement within that complaint.
All right, your time is up, so I think we're going to have to leave it there, but let me see if there are any further questions. No. All right, thank you both for your arguments. It's an interesting case, and we've been aided by your briefs and your argument, and the case is submitted.
Thank you so much.
The next case, and our final case for this morning, is 2022 P0695 Marie Coleman versus Cambridge Savings Bank. Is it Attorney Reiling?
It is, Your Honor. Thank you.
Thank you. We're ready whenever you are.
Thank you, Your Honors. Good afternoon. Richard Reiling appearing this afternoon on behalf of the appellants Marie Coleman and Alda Soares. As Your Honor is aware, This case involves two former employees of Cambridge Savings Bank. They both claimed that they were subjected to a hostile work environment and ultimately terminated in violation of the laws in the Commonwealth against discrimination, as well as the policy of progressive discipline. This case involves a summary judgment decision. A review of the decision shows that the Superior Court found that there was some evidence, weighed the evidence, and took the issue away from the jury. And in regards to the evidence that was presented, the trial court minimalized that and dismissed it as speculative. So as a preliminary matter, of course, in a summary judgment setting, it's not the role of the Superior Court to weigh the evidence, especially in cases involving discrimination, when the decisions from the Supreme Judicial Court have made it clear that summary judgment in that context is highly disfavored. And the reason for that's pretty straightforward, as set forth in the Sullivan v. Liberty Mutual case, and that's because the question of an employer's state of mind is elusive and rarely established by anything other than circumstantial evidence. And in this case, as clearly set forth in the briefs, both Ms. Soares and Ms. Coleman have submitted evidence of a discriminatory atmosphere.
Can we, unless I misunderstand the posture of the case, we're really talking about the final stage of the burden shifting analysis, the pretext, correct?
It is, Your Honor, but
Okay, so can you tell me, so count one is the age discrimination claim, and that pertains to both plaintiffs, correct?
Yes, Your Honor.
And then count two is the race discrimination claim, and that pertains to only
Ms. Coleman.
Coleman. Okay, so why don't we take the evidence of that, the evidence that you contend was enough to get you over the summary judgment bar on pretext with respect to count one.
Okay, and that's the age count, Your Honor.
Yep.
All right. Again, as set forth in the record in the brief, first of all, evidence was presented of a discriminatory atmosphere. Specifically, unrefuted testimony was offered that the bank preferred younger employees for hiring and promotion to management positions because they were more compatible to customers that the bank was attempting to attract.
Was that actually evidence, or was that a statement of opinion in a deposition?
Ms. Soares testified to that during the course of her deposition. Ms. Coleman testified to that during the course of her deposition. Both of those individuals were in management positions. One was the manager and one was the assistant manager of a bank. In addition to that, the sworn testimony of the assistant manager of the Arlington Heights branch testified that on two occasions he was told he was too old for his position, should accept a demotion to a personal banker position, and was subsequently terminated.
I'm looking at Record Appendix page 316, which is in the Soares deposition, where she said, and I know at least two people that happened to them, talking about offering someone a lower position who was older. It feels like they don't wanted people to older people. It was more like all these young crowds, which is great. They come at lower pay than us, probably, I'm assuming. I don't know for sure. She says below, so that's how I feel, basically. Does that constitute evidence, someone's feeling, or?
Well, I think if we look at what Ms. Soares likewise testified to, she testified that she was specifically frequently questioned, and this is on page 363 of the appendix, her interest in the management position at her age, and suggested that she may want to do something else at her age. There were also comments which a trial court emphasized related to her dress. Now, taken in context with the testimony from the Arlington Heights branch, the fact that the appellants likewise presented evidence that three white males under the age of 40 filled management positions at the banks during these periods. Again, the comments that were being made directly to them. I certainly understand, Your Honor, that her testimony at that particular place in the transcript, perhaps wasn't as forceful as it could have been. But when you take into consideration what's actually being said to her, hey, you're getting a little old, maybe you should consider another position in the bank. You're not dressing your age. And then we look at, what happened to the assistant manager of the Arlington Heights branch, told he was too old for the position to take a lesser position, and ultimately terminated. Under those circumstances, again, when we're looking at this from a summary judgment standpoint, and we're looking at whether circumstantial evidence of a discriminatory atmosphere, which of course the Supreme Judicial Court says in the Lipschitz case should be considered, when you take that evidence, there's certainly some evidence of a discriminatory atmosphere. Of course, we feel that it's strong evidence, but nevertheless, it gets you over the very low bar for summary judgment. Whether that evidence is sufficient, whether it has sufficient weight to demonstrate that the bank has these discriminatory policies, will ultimately to be decided, and it'll be ultimately decided by the trier of fact, the jury in this case. And then we also have the ultimate evidence in regards to who the bank replaced these two managers with. Men under 40. Both cases, both decades younger. So their subsequent acts, after the termination is consistent with this policy, and these repeated questions that managers who are in the protected class are being asked. Under those circumstances, a reasonable jury could decide that perhaps either way. We're certainly not standing here saying that a reasonable jury would have to find that
Plaintiff Soares said that she believed that they were hiring younger people to these positions so they would have to pay them less. Was there evidence in the record as to how much the two replacement employees were being paid?
There was not, Your Honor. There was not evidence of that. She did, though, testify, and Coleman did as well, in regards to 3 such hirings.
Is there evidence in the record, this is anecdotal, was there evidence in the record as to the managers that the company employed in terms of their overall age? The ages of all of the managers?
That the trial court did mention in the opinion. That was asked for in discovery, was not provided, and the trial court faulted the appellants for not compelling that information. But that information was not in the file.
So was there a motion to compel file?
There was not.
Okay.
With that understanding, we're left with the evidence that was presented in connection with these hirings, in connection with these comments that were being made, and in regards to another assistant manager who was let go. So in regards to age, there is certainly material issues of fact here. Again, it appears from the trial court's decision that the trial court is taking this evidence that's being presented, discounting it, and weighing it. That's not the trial court's role. It's clear from the trial court's decision that the trial court would have liked to have seen more evidence, perhaps would have liked to see the motion to compel filed, or some more information related to the demographics. But nevertheless, based on the evidence that was actually presented, that evidence is sufficient, again, at the summary judgment stage, to allow the jury to fulfill its function and weigh this evidence.
What is, to get back to Justice Wolohojian's initial question, what is your best case factually that the evidence put forth here in the summary judgment record was sufficient to show pretext?
Your Honor, I would suggest that the Lifshitz v. Raytheon case from year 2001, which talks in detail about the discriminatory atmosphere argument, and finding that while that's not a conclusive proof of discrimination, nevertheless, it's admissible to show motive. And it's also admissible to show an institutional state of mind. And again, there is certainly some evidence, not just limited to these two appellants, that shows an animus against people over a certain age. Perhaps for business reasons, within the bank's practices. But nevertheless, it's there, and it was specifically expressed to these appellants. Moving on to the race-related issues. Again, what we have here is circumstantial evidence. What the trial court doesn't mention in its decision is the bank's hiring practices to start with. First of all, the executive committee of the bank is entirely comprised of Caucasians. There was no steps to ensure a diverse pool of qualified candidates for open positions, and no policies and procedures in place in regards to the hiring of a diverse workforce. That doesn't come from the appellant's testimony. That comes directly from one of the bank's managers who's discussed in detail, Ms. Sexton. We also know that only 2 African-American managers were hired to manage the bank's locations. The appellant, Ms. Coleman, and Donna Smyth. They were both hired at the same time. They were both dismissed at the same time. Ms. Coleman testified at length regarding the...
What do you mean dismissed at the same time?
They're both fired in the same year?
No, right, but not at the same time for the same incident, correct?
No, I'm sorry, Your Honor. They were not fired for the same incident, but they were fired within weeks of each other. The only 2 African-American managers were hired at the exact same time, but they were ultimately fired within a very short period.
What was the non-plaintiff fired for?
The record's a little unclear on that, but she was ultimately terminated for non-performance of her job.
And do we have details as to that in the record?
We do not, Your Honor. What we do have is the fact that, that again, the only 2 African-American managers hired at the same time, let go within a very short proximity, of each other. Ms. Coleman also testified as to the unwelcoming work environment. She testified that she was being hounded by her supervisor, and both Ms. Coleman and Ms. Soares testified that it was made well known to them that they wanted to fire Ms. Coleman. Additionally, Ms. Coleman witnessed what she believed to be, racist statements concerning the dress of African American employees while she was in the branch. Under those circumstances, again, when taken in the context of the bank's known hiring practices concerning, the bank managers, and the close proximity of the firing of the other African-American bank manager and the way that Ms. Coleman was treated, again, it constitutes some evidence of a discriminatory atmosphere. Again, whether that's sufficient raises a
You're talking about the discriminatory atmosphere cases. In my mind, I'm trying to think of any discrimination cases where that was used in a case where, here there was clearly cause for termination. They had violated the 2 code or whatever rule for the safe.
And Your Honor, I realize that I'm nearly out of time here, but as we've stated in the briefs, we believe that there's numerous facts that a jury could use to discredit the explanation for the termination. And the judge actually, in her opinion, cited some of those. So, you know, whether a reasonable jury would find that these were adequate grounds for termination in the face of this discrimination, you know, really is a factual issue. And again, since I'm almost out of time here, we discuss in detail in the brief, and the judge actually discusses in her decision the mitigating circumstances, including the need to open the branch and lack of training and so on.
We're going to have to leave it there because your time is up, but let me see if there are any further questions. No. All right.
Thank you,
have
Your
your
Honors.
argument. Thank you.
Good morning, Your Honors, and may it please the Court. This is, I think, about as straightforward as an application of established precedent as there can be in the employment realm. This is a case where the motion judge summed it up precisely correctly in saying that there is, quote, undisputed evidence of a legitimate reason for the plaintiff's termination, close quote, and no, quote, concrete specifics, close quote, to sustain plaintiff's burden of showing pretext. That's what happened here. And what you heard in the plaintiff's argument here was nothing to address the reason for their termination.
Well, no, but it goes to whether there was sufficient evidence of pretext.
Pretext, correct,
Right.
which is in
No,
this.
I don't think they're disputing that the violation of the bank's policy occurred.
Correct, nor could they on this record because they both admitted to it.
But we've got one employee who's got an unblemished record for decades at the bank, who is not even there, I take it, on the day that the violation occurs, but is somewhat involved because she happens to have a copy of the second set of codes in her desk.
Correct.
That employee is fired.
Correct.
Where there's evidence to suggest that that the bank wants a younger workforce.
There is no such evidence of that, Your Honor.
Okay.
There is the plaintiff's speculation of what certain things felt like to her, as Justice Neyman pointed out. That's the evidence in the record.
Apparently, the fact that both employees were replaced by younger hires.
Correct.
Okay. So, and then we've got a whole statement of countervailing facts that I take the bank did not dispute or respond to.
If you're referring to the items that were in plaintiff's brief, the bank did respond to those.
No, I'm talking about in the statement of facts, which is in record appendix.
The additional statement that was submitted in violation of the rule, yes, Your Honor. There was no provision in the rule for the bank to respond to that, so those comments became part of the record. We did address why they don't go to the core of pretext. Again, the question of pretext in this context is, did the bank act for the reason it said it did? Not whether the bank was right, not whether the bank made the best business decision possible, not whether the bank failed to consider other alternatives, such as a suspension or some other penalty to impose.
Can we, before we go there, can we go back to my question?
Of course, Your Honor.
I'm looking at the plaintiff's Rule 9A statement of additional facts that preclude summary judgment.
Correct.
Which are unrebutted.
Unrebutted in the sense that there is no provision in the rule for that. There was no provision in the rule for those to be submitted in the first instance, which we mentioned in our brief, in our reply brief.
I've seen these commonly, and they're usually then have a responsive dispute. That didn't happen here. So if they're not disputed, I take it there was no motion to strike them down below.
Correct.
Then how is it that they're not just taken at face value as part of the summary judgment record?
Even if they are, Your Honor, none of them address the bank's reason for its termination decision. The bank terminated their employment, Ms. Coleman and Ms. Soares, because they were branch managers, or in Ms. Soares' case, assistant branch manager. No more significant duty for a branch manager or assistant branch manager at a bank than to follow the rules that apply to opening the vault.
Okay, so
that's on the
number
premise.
15 in there
Yes.
says, by 2015, it was the standard policy and procedure of the bank to prefer younger employees for hiring and promotion to management positions, as it was the bank's view that younger employees were, quote, more comparable to the customers that the bank was attempting to attract. Accordingly, the bank made it a practice to hire white males under age 40 to fill bank management positions. These hires during this period include the following, and lists 3 managers. Then paragraph 16 and paragraph 17 also set out allegations of age-based behavior. As I said, these are not rebutted.
Correct, Your Honor. And even if they're taken as pled, they do not address the core issue in this case. And this is the teaching of Sullivan, the SJC case from 2005. Evidence that does not address the employer's asserted reason for its action does not satisfy the burden of demonstrating pretext.
Why isn't that an inference for the jury to draw? So the jury has, at least in the case of Suarez, a long-term employee with an unblemished employment record, who on this occasion stored some codes in a locked drawer on her desk.
In knowing violation of the bank's policy.
And then was fired.
Yes.
Right? And there's an allegation that the banks have a policy of progressive discipline. There does not appear to have been any progressive discipline in this case. There appears to have been an outright termination. And then we have all of this stuff that's unrebutted about, you know, banks' policy and of wanting to hire younger people. These people are, in fact, replaced with younger people. Why isn't that not enough for a jury to conclude that when you fire a long-term employee in these circumstances, you're really, that termination was a pretext for discrimination?
Because the SJC has said that that's not sufficient.
Where did they say that?
In the Sullivan case, Your Honor. The SJC said very clearly that evidence submitted by a plaintiff that doesn't address the employer's reason for its decision is not evidence that can demonstrate pretext here. Because what that is, when it doesn't address the employer's actual reason, it's an invitation for a jury to decide whether or not, as plaintiff put in their brief, whether there was an abundantly correct decision by the employer. That's not the question that needs to be answered, that can be answered by a jury. The only question that can be answered in the
Why don't you give me an example of what that would mean in this case? What would the evidence, what in your view would have been evidence that would have gotten them over the bar?
It would have been evidence, Your Honor, that, for example, and this comes from the Matthews versus Ocean Spray case, evidence of another employee, another manager who violated the same policy or one similar and was not terminated. There's no evidence of that in the record. In fact, the evidence is the bank is unaware of any other manager or assistant manager who knowingly violated the security policy with respect to the vault codes in the branch. The bank is unaware of it happening at any other time. They found out that it happened with respect to Ms. Coleman and Ms. Soares. They eventually admitted to doing it, so there's no dispute about that. And the bank decided to terminate them. Consistent, I might add, with their progressive discipline policy, which says the bank reserves the right to impose whatever form of discipline it sees fit in a given circumstance. That's the kind of evidence the plaintiffs have to come forward with, not some ephemeral, ethereal, maybe there's some atmosphere over here based on what things feel like to Plaintiff Soares. They need to address the actual decision here which they have not done, and that is why the motion judge correctly granted summary judgment on their claims. And I'll be glad to address any questions. Otherwise, I'll move on very briefly to the promissory estoppel claim.
Well, I don't think they raise any argument on appeal regarding the promissory estoppel.
I would agree with Your Honor on that. Then if there are any other questions,
I don't see any.
thank you very much.
All right, well, thank you both. We've been helped by your able arguments on both sides. And with that, the case is submitted, and we're going to stand in recess. All right, please. Good job.